Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican, please. Verbal watching.
Literally not true.
Is that correct?
I didn't ask you to interrupt me. Oh, for Trump's sake.
Good morning and welcome to the Court of Public Opinion. I am the Recovery Addict. Hope you're all doing absolutely fabulous this Tuesday morning. Happy Tuesday to you. Allie's wrapping presents for all of us, so bring the gifts. Bring your own tape, bring your own wrapping paper. She'll do the work, which is great. Let's see, Camilla Juliana, congratulations. You're first in chat this morning. We're super excited about that, mostly because you have to do the work and we don't. I know it's sort of bad of us to celebrate that, but hey, we'll take what we can get. Let's see, let me put you back where you belong here a little bit. It's a little bit low. There we go. That's better. That's better. Congratulations, Camilla. This is going on your permanent record. You are, in fact, the internet owner. Everything IP related is your responsibility until we go live again. All right. Allie G says, I love rapping. If I didn't feel like I was drowning in kitty gifts, I would so offer to rap any that wanted. Oh, Allie, I volunteered you, or voluntold you, one of the two. Yes, it's wonderful. All right. Speaking of rapping, what'd you bring me? My daughter just brought me not one, not two, but 3 blueberry muffins. 3 is, I think 3 is a serving size recommendation from the Surgeon General's warning or whatever. I think 3 is the right number. That's exciting. I did not get breakfast. Now, if she will bring me a large glass of milk, then she will be my favorite daughter. And I'm sure she wants that status. She happens to be my only. She's like, there's only one. I am spoiled. I have the best kids. Oh, good morning. Let's see. We have a couple things to do, so we've got to get birthdays done, and then I've decided we're going soft hunting. You, me, all of us, we're going on a hunting expedition. 'Tis the season. 'Tis the season to hunt. And we're hunting for soft sits. And no, we're not. We're like photographers hunting soft sits. That is our tool. Our weapon of choice is the camera, and we're going to look and see if we can find one today. And they're hard to find, but we know where they frequent. We know where they frequent. So now I'm feeling a bit Elmer Fudd. Yes, if you've got an Elmer Fudd hat, now is the right time to wear it. It would actually help us increase our odds. We have 2 belated birthdays to sing about and 2 for today. Oh, 2 and 2. Nice. That'll work. Gonna catch a big one. Yes. And y'all can take screenshots when we do. Did we ever find out what happened to the soft sit in Thurston? Leonard Blatt. Are you talking about? Oh, yes. Perfect. It's even. Okay, now I have a cup full of milk in one of our official mugs, and I need to find a place to put it where, A, I will remember to drink it before it gets warm, and B, it won't spill on everything. Right up there looks perfect, high above all the electronic equipment. We'll keep it right there. No cords to make it. I just won't have to. I can't grab the goat because that would be a problem. But the one they gave to the new judge, oh my goodness, I don't remember if we saw the ending on that one. Or what happened. Okay, we have some birthdays. Belated birthday to Tori and Karen, and then happy birthday today to Donna Littlefield and Steve. We're going to sing as if Tori and Karen had a birthday today, and we're going to obviously sing to Donna and Steve in the same way. So everyone, join with me. Stand up wherever you are. And when I say everyone, I mean everyone. Everyone sings. I know some people say, well, I don't sing. You haven't heard my voice. Well, that's because you haven't sung yet. Sing louder and I'll hear it. But it's okay. Everyone sings. Everyone's able to sing the birthday song. Well, there's a buffer. And Holly Mack. We're adding Holly Mack. That's 5. 5 is a handful. There we go. So everyone, wherever you are, stand up, take your breath, shoulders back, project your voice to the back of the room, blend your voice with a neighbor, and warm up with me if you will. La 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 la. Holly Mack says, I put it on the sheet. I put it on the sheet. I did the thing. All right, we were going to sing to you. Happy birthday to you. Happy birthday to you. Happy birthday to Victoria, Karen, Donna, Littlefield, Stephen, Holly Mack. Happy birthday to you. Ooh, that was close. Tori, Karen, sorry. Happy belated birthday to you too. Donna, Littlefield, Stephen, Holly Mack. Happy birthday to you today. It's your birthday. Thank you very much. I realize there are many wonderful days. Today is your special day, and I realize there are a million places you can be and a million people you could have celebrated with. But no, you chose to be here with us. And the privilege, the pleasure, the honor, the joy is ours. Hopefully we can turn some of that joy back to you, make your day a little more specialer. Begin by helping yourself to free pancakes at Denny's, IHOP Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and Cracker Barrel. I think I missed one in there. If they serve pancakes, tell them it's your birthday and you should get them for free. Like 99% of the time, that works. Or so I'm told. Whew. Marianne, I'm sick with the ick, but I'm doing my best to sing. It sounds great, Marianne. Thank you, thank you. High kicks in full force. 80s Music Command has been forcing the dancers to practice, practice, practice. It's definitely a choice to be here, says Blue Stars. Regina Crawford, I'm late, but happy birthday. Yes, it's still time. He's a drill sergeant. I need just a little sip of the good stuff here. That is good. I'm sorry, but milk is an underrated beverage. Don't at me. So good. Free pancakes. Happy birthday. Let's see. Yep, it's the drum solo time. Everyone help me with the drums. Everyone plays the air drums, even if you're in the car. Make that snare snap. Beautiful. I think I did like a snare to cymbal on the end, but it worked. It worked. It sounded perfect. Let's see. Josh says, you have a delivery, and it's most likely not fitting in your P.O. box, or it might not. Okay, so my P.O. box is built to accept 3x5 cards. You know, like the little cards that your teacher used to let you take notes on. You say, can you bring one 3x5 card into the test, and you'd write like minuscule small, and then bring a magnifying glass to try to read it. That's the size of P.O. box I have. So pretty much anything larger than that, which is pretty much everything, I have to get over the counter, which is funny because it's against federal regulation, like post office rules, to hand mail over the counter. Why? I don't know. I don't know what's so sacred about the counter, and you can't, no mail shall cross here. But literally everything I get, I have to have handed to me over the counter, right in front of the sign that says it's against it's a felony to do this. It's definitely violating postmaster guidelines by not getting an appropriately sized P.O. box for his needs. Okay, this may be a thing, Greeners. They do tell you, they recommend that you get the size of post office box to accept the mail that you think you're going to receive. And I think I'm just going to get bills. That's my thought process going into this. Holly Mack says, thanks, Ari. First time on my actual birthday. Much love to you. Holly Mack, happy birthday. Super excited that we were able to sing to you on your birthday, and hope you have a wonderful one. It is awesome that you're here. Thank you, thank you, thank you. We have a couple things. First of all, Judge Middleton has a song of the day which we have to listen to. Well, not really listen to because that'll get us a copyright strike, but we get to listen to the lyrics of. So let's do that. Judge, are you there?
People stop me on the street and say, hey, I know every one of those songs. Mm-hmm. And I say, good for you, our little shared moment of humanity. Today's is pretty easy. I always liked this song. It had a resurrection later in life. And tomorrow we'll do maybe a follow-up from this one. Well, I don't know why I came here tonight. I got the feeling that something ain't right. And I'm scared in case I fall off my chair. And I'm wondering how I'll get down the stairs.
Okay, that's a
I'll
dead
give you the
giveaway.
next line, even Tim George will know it. Clowns to the left of me, jokers to the right. Here I am. And here we are. Good morning, Mr. George. Thanks
It is
for being
Steelers
here.
Wheel, stuck in the middle with you.
I've got both you and Judge Patterson this week. So.
Do you have any of the prelims? You don't.
We sent over a stip on the show.
I did. I haven't got a date. Maybe when I get you for a minute, we'll see what, because we're obviously going to get bumped into next year.
Right.
He's posted his bond, so it's not as urgent as it was. So we'll see. Clowns to the left of me, jokers to the right. Here I am. Yes. All right. So we got, as I said, the rest of this week. I have a meeting at lunch today. The county's Christmas party is tomorrow. And a meeting Thursday and a meeting Friday. Next year, I'm going to boycott lunchtime meetings. The song got a resurrection from Pulp Fiction. That scene with Michael Madsen getting ready to slice somebody up, sort of shuffling to that. Gave it some new life. But like I said, the only common denominator in these are that I like them.
Shared humanity.
And
I want the judge's playlist.
good morning.
Good morning, Judge.
I'll let this run a minute. Mr. George is here for the ordinance cases. And I always appreciate their being here. Just for both the Three Rivers and the Sturgis cases, it makes my life and the defendant's life much easier. As you saw last Thursday, we had a difficult day. 7 people have to come back tomorrow because we weren't able to deal with them last Thursday. So hopefully we won't get in that situation. Yes, most of these are songs from your dad's time. Yesterday, Such Great Heights is from somebody younger's time. I haven't done any 80s songs. There's hundreds of them. I own almost every 80s song on a CD. Well, he's ahead of me. Anyway, we'll see how we do today. Judge Patterson, as I said, has the pre-exams. I do have a couple of sentencing stuck in here. Also, I wanted to see whether Mr. Boggs paid on his fines and costs, which he did. So we're going to have a relatively light morning. Tomorrow we have an arraignment morning, and then we have a zoning continued saga of Critter Creek Farm in Fabius Township. And so that will be tiring. Vivian has logged into my courtroom for Oswaldo Ramirez Gonzalez. We'll see whether he ships up. She may also be needed next door.
Good morning, sir.
Good morning. Well, we have 1, 2, 3, 4, 5, 6, plus Mr. Stickley. Good morning, everyone. Mr. Beerline, I think you're supposed to be in the courtroom next door. Yeah, we charge admission on this side. It's free over on that side, so you can go over there for free.
I love Judge Middleton.
All right, everybody, good morning. Let's get started. Good morning, Mr. Stickley.
Morning, Judge.
You look like you got what I had.
I'm on like 2 weeks. I get better. And
Yeah, it's been pretty. All right, well, let's get started. Clowns to the left and me, jokers to the right. Here I am.
Stuck in the middle with you. I'll pay admission. I would as well. This courtroom has got to be a blast.
Guess he was pretty prophetic about 45 years ago.
He's making commentary about his current work environment. Clowns to the left of me, jokers to the right. Oh, man.
Don't know why I came here tonight. Well, something ain't right. All right, we're ready to go. Michelle's here, Keith's here, Mr. George is here, Vivian's here. I appreciate everybody who helps us make this happen every morning. I'm in here doing this by myself, but I'm really not. It takes lots of people to make this simple arraignment process work, not to mention all of my staff. Vivian, I'm ready if you are.
I'm ready. I have my camera turned off because I think where I'm at, the reception is not that great.
All right. Well, thank you for joining us. Well, first thing I'm going to do, wherever you are, would you please raise your right hand?
All of us, everybody.
Yes.
Not you guys. I'm sorry. But thanks anyway. I wasn't very clear on my instructions. I'm going to swear in the interpreter.
Oh.
And Luke. You swear or affirm to the best of your ability you will interpret these matters from Spanish and English into Spanish.
I do.
Thank you. Luke, are you here for Mr. Harvey?
No, Judge. It was Mr. Philip Yoder, Village of Constantine.
All right. Well, I may need your help on Mr. Harvey.
Okay.
But we'll see. All right. Senor Oswaldo Ramirez Gonzalez, would you come forward, please?
Puede pasar adelante, señor Ramírez González.
I did. Don't bring it any.
Okay, that's what I wanted to see. I didn't want to have them sit around for.
No, don't bring it any.
Okay, thank you.
Thanks. Buenos dias.
Buenos días.
¿Es usted Oswaldo Ramirez Gonzalez?
Sí.
Yes.
The lady that's helping us, you can't see her, but she is a certified court interpreter, and she's going to translate and interpret for us.
La señora que está en la línea, no la puede ver, ella nos va a ayudar. Ella es una intérprete jurídica certificada.
You got a ticket in Three Rivers on November 25th.
Te recibió una multa en Tres Ríos el 25 de noviembre.
For driving without a valid operator's license.
Por conducir y no tener una licencia de conducir vigente.
We get lots of those tickets, hundreds.
Recibimos cientos de ese tipo de multas.
Okay. It is a misdemeanor.
Es un delito menor.
It is punishable by up to 90 days in jail and a fine of up to $100.
They never do the jail.
Conlleva la máxima penalidad posible, hasta 90 días de cárcel, la multa hasta $100.
Plus cost.
Más costos.
Let's take a look at your ticket.
Vamos a echar un vistazo a la multa que le di.
excited. We're going to check in with the judge here for a little bit before we might have some reading to today. It's follow up to what we watched yesterday, which is extremely interesting for me. Hope you guys liked it as well. But
you got the ticket at Broadway and Constantine Street.
Usted recibió la multa entre las calles de la Broadway con la Constantine.
At 8 o'clock in the morning.
A las 8 de la mañana.
On November 25th.
El 25 de noviembre.
You got a ticket in October.
Recibió una multa en octubre.
And it says you don't have a valid license, but you have 2 points on your license.
Dice que no tiene una licencia vigente, pero tenía 2 puntos en su historial de conducir.
You have points on a non-existent license.
Well, we had a couple walk in, so we're always open.
Josh, I've got to go and get them. I'm so excited.
Anyway, sir, the normal fine for that is $100 plus $125 of costs, $225.
Normalmente la multa son $100 más los costos de 125, un total de $225.
How do you plead to that charge?
¿Cómo contesta usted a ese cargo?
Culpable.
Guilty.
Culpable.
Guilty.
Did anybody threaten you to get you to plead to that charge?
¿Alguien le amenazó para que contestara culpable?
¿Puede repetir?
The interpreter will repeat. ¿Alguien le amenazó para que contestara culpable?
No.
No.
Or promise you anything?
¿O le prometieron algo si contestara
No.
culpable? No.
No.
It's pretty much just a fine.
Where were you going?
¿A dónde iba?
Probably work.
Venía del trabajo.
I was coming from work.
Trabajo.
Where do you work?
¿En dónde trabaja usted?
Limpiando bones de maíz.
Cleaning something of corn.
Okay, down in Constantine?
Ya.
In Constantine. Yeah.
All right, well, you can't drive because you don't have a license.
Usted no puede conducir porque no tiene licencia.
How did you get here today?
And I can't fix it.
Y no puedo arreglarlo.
Does work with corn.
How'd you get here today?
¿Cómo llegó aquí el día de hoy?
Uh-oh.
Me trajo un amigo.
A friend of mine brought me.
Okay, that's the right answer.
All right, do you have a way to get back forth to work?
¿Tiene forma de ir y venir al trabajo? ¿Alguien más le puede llevar?
Sí.
Yes.
All right, the fine is $100.
Multa 100.
There's a $75 crime victims' rights fee
$75 para víctimas de delito.
and a $50 fee that goes to the state.
Y $50 que va al Estado.
The state's just cashing in.
The
on
state
these
requires
crimes.
that I put that $125 of costs on every case.
El Estado requiere que agregue $125 de costos en cada caso escuchado.
So the total is $225.
El total son $225.
Can you pay that today or do you need time to pay it?
¿Puede pagarlo hoy o necesita tiempo para pagarlo?
Puedo pagar hoy.
I can
Needs
pay
time.
it today.
Very good. I don't have
Muy
a
bien.
way to fix this because you can't get a valid license unless you have lawful residency status.
No tengo forma de arreglarlo porque usted no puede obtener una licencia de acá sin regularizar su situación migratoria acá.
You just can't
There are
drive.
some states where you can do that.
Michigan is not one
En
of them.
algunos estados eso se puede hacer,
But Michigan isn't one of them.
pero Michigan no es uno de ellos.
I just read that the federal government is threatening to take funding away
Acabo de leer que el gobierno federal está amenazando con quitar los fondos
from the states that do give a license to people that don't have lawful residency status.
a aquellos estados que sí le conceda una licencia de conducir a las personas que no tienen regularizada su situación migratoria.
All right, good luck, sir. I'll have the bailiff take you out. You can pay the fine, and you can just have to find a way back and forth to work.
Buena suerte, señor, que el alguacil le va a acompañar.
She will take you out to the county.
Acompáñale al oficial, le va a llevar a pagar y que su amigo le lleva y le trae del trabajo.
Okay, thank you.
All right.
Anything else for the interpreter, Your Honor?
Nope.
No, I think Judge Pattison might need your help next door.
Yes,
But
yes, that's where I'm
that's
headed
it for-
next.
All right, thank you very much, Vivian. I always appreciate your help.
Vivian, make and
You're
bake
welcome.
on
Have a
the
good day.
road. Did a great job, Vivian. Nailed it.
All right, we always start with the interpreter's cases because she's usually needed in more than one place at a time.
She gets paid by the hour, so don't
And
keep
as
her
it
waiting.
turns out, she's needed next door. It does take longer to do those, but often they resolve easily. Mr. Dofsinger is here on Philip Yoder. Let's talk to him. Mr. Yoder would come
Philip
forward,
Yoder.
please.
This name sounds familiar. Do you guys remember Yoder? What's that about? Maybe that's just a popular name in the area.
Good morning. Are you Philip?
Yes, good morning.
Aubrey Yoder from Middlebury? This is 25774OT. This case has got a little history to it. I have to get used to doing it without an interpreter because I can talk faster. You got a ticket back in April, and the officer didn't give you a notice. So we sent you a notice in May. We sent a notice on April 30th for you to appear on May 13th. He didn't come on May 13th. So
Yeah, I found that out the very hard way.
yes,
You know.
well, I usually do an orders of show cause. Judge Pattison issued a bench warrant,
Ooh.
and then you got picked up on the warrant on November 3rd and posted a $500 bond. Then you failed to appear for your arraignment on November 24th, and Judge Pattison said a $1,000 bond. Then you called on December 12th and realized you missed court. So they set it in front of me today. So the good news is we got a $500 worth of bond, which is more than enough to cover any fine here. But the lesson is show up for court.
Yes,
Yeah.
I'm in the process. Was in the process of moving, and
Well, let's talk about the original ticket.
Back door.
See what the deal is.
Royal Oaks is live
You got
as well.
a ticket in Constantine way back in April, and 3:00 in the afternoon. No license ever applied and no proof of insurance. It looks like maybe the no proof of insurance got defaulted. That's a civil infraction. When you don't show up on a civil infraction, they just show a conviction. No license ever applied. 904A, that particular version of driving without a license is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to, I've been saying 500. I looked at it again the other day. I believe it's 100. You have some Indiana issues, so it shows there's no license ever acquired. Mr.
Indiana
Knopfinger,
issues.
does the village have any offer on this case?
It's a quick question for you, Judge. Prepared to offer a 257-301. Don't have access to his Indiana driving.
This is actually better than a 301. I don't think this one carries any points.
I would, given the time here, we just offer that as charged with a recommendation of fines and costs.
All right. The fine would be the same as the last guy, $100 plus $125 in costs. You have $500 of bond, which is more than enough to pay your fine, and I'll give you the balance. How do you plead to the allegation that you were driving a Constantine that day back in April and you didn't have a valid license?
How do I plead?
Yeah.
Not guilty.
Okay.
Fight it.
Do you have a valid license?
I've done everything possible in the state of Indiana. I paid over $3,800 worth of fines. I took a defensive driving course. When I got stopped in Constantine, I figured out there was a fine I had to pay in Indiana, and I took a 4-hour defensive driving course. I figured I paid the $125. I don't know, it wouldn't be a reinstatement fee, but for the course or whatever I had to pay for. And
you're still trying to get over the hump.
I just don't understand what I have to do.
Well, I don't have your Indiana record. Luke, we got a couple options. We can reset this and you can continue to fight with Indiana, or you could do a 257-326, which wouldn't show up on his driving record.
Given the time he spent problems here, Judge, really what we're looking for is resolution in the case, and then he pays the fines and costs. So I can live with that.
All right. Let's talk about that. We use lawyer talk. 257-326 is the section of the motor vehicle code that's called allowing another to violate the motor vehicle code. It is a misdemeanor, although a very minor one. It's punishable by up to 90 days in jail and a fine of up to $100. The good news is it doesn't go on your driving record and doesn't carry any points.
Okay.
So it won't affect your ability to continue to try to get your license in Indiana.
Okay.
That's the benefit of that charge. So the village offers that. Is that acceptable to you?
I can pay all my fines by next Monday.
Well, I can pay all your fines out of your bond. I believe I have $500 in here. Let me look. Yeah, I have more than enough money in bond that you posted to pay all your fines.
Okay.
You got a speeding ticket and you got this no insurance, but I think there's enough money to cover all of it.
Okay.
Then you'll be square with St. Joe County, Michigan.
Copy.
And it won't go on your driving record, so it shouldn't affect your Indiana.
Yes, sir.
So are you willing to plead to that? Allowing another to violate the motor vehicle code? It's a weird one.
Okay.
The other, you allowed someone to violate the motor vehicle code, but that means you allowed yourself to violate the motor vehicle code. But they use it because it doesn't carry any points and it doesn't go on your driving record.
Okay.
But frankly, the village still gets the fine.
And just to clarify, my mother's she's a bus driver in Portage, Michigan, and she took me here today.
All right, very good. She'd bring you on the bus?
No, she drives the special ed bus, and they wouldn't have a harness big enough for me. Maybe I don't know.
There's a special place in heaven for people that drive that bus.
Yeah, she's got the patience of.
Yes, and they don't pay them enough for the love they give to those kids. But
yeah.
All right.
So hold on just 1 second.
You didn't ride that bus.
We're gonna mute the judge.
But you were ahead of me on my question. All right.
We're gonna mute him for a second. We're gonna jump over here. Let me show you what I'm doing on the background. We're watching everything we possibly can to see what's happening. And in the midst of this, while I'm watching 4 courts, Josh just found a 5th one. So hold tight for just a second. Let's jump over to this guy. or gal, I should say. Boom. Just trying to find the Stacia Buchanan is where we're trying to get to. Stacia Buchanan. There she is. Found her. All right, give me a second. Josh, you said this was just an hour ago, just this morning. That's this one here. Let's see. Let's jump there. All right. Made it. I think this is the one. Just waiting for her to get going this morning. Turn the mics on. There we go. How court hopping works, yes. It's wild. Don't get too attached to any court because we're probably going to bail in search of the next best sovsit.
Miss Olivia and Miss Detavanage, I'm not sure how to say that. You're both here for the same. You're both here for the same case and for a pretrial. So I normally ask if you want to have a breakout room to talk about either the case or getting the case ready for trial before we begin with your pretrial. Are you willing to meet in a breakout room?
Plaintiff is. Yeah.
Okay, I'll put you in a breakout room. Just remember when you come back from the breakout room to remain quiet and muted until I get to you, just in case I'm in the middle of a hearing for someone else. Please stick to.
Thank you.
Thank you. No music, Your Honor. I'll turn it down. Do we need a hunting license? No. Sovsits are always in season. Any weapon, any time of the year. It's like jackrabbits. I'm sorry, but they're, yeah. 24 hours a day, day or night. No bag limit as well. I'm going to have to skip ahead. This is how we hunt. This is how we hunt.
Okay. Mr. Whitty and Mr. Cunningham, come forward, please.
Here we go. Step right up, grab yourself some hand sanitizer, and let's get this case underway. Oh, he's got the Carhartt flannel. This is going to be good already.
On the record, Fox Land Holdings LLC versus Jason Cunningham and all others, 2506562LT.
Good morning, Your Honor. Norman Whitty appearing on behalf of the plaintiff, Fox Land Holdings.
Are you Jason Cunningham? Today's the date for our adjourned landlord-tenant hearing. Back on December 2nd, the parties agreed to recess this to today's date. Are we holding a hearing this morning?
We will be, Your Honor.
Okay. Then we're going to first start with determining whether there's a triable issue. What I see here is an allegation of unpaid rent and a request only for possession. Mr. Whitty, how much money do you believe, and break it down so that we can discuss it, Mr. Cunningham owes at this moment?
Your Honor, at this time, we're showing rent to retaining the amount of $2,373.02. Court costs in this matter are $159.75. Total amount to retain is $2532.77.
Hey, but
Your Honor, I also note, and I have photographs of it, there was a money order that was tendered that was basically torn in half, so it's not negotiable. So we have that. It's not present in the courtroom, but that can be returned to him so that he can have it reissued. The amount of that money order.
It was torn in half?
Not clear to me looking at this. the portion that would have shown the amount is missing. So we don't have that part of the money.
Usually it's both in numbers and then also written in words, isn't it?
There's a chunk missing here too, so but it's kind of a scrap of a money order received, so.
He shredded
At
it.
any
and
rate,
then
it's
gave it
not
to-
something we can negotiate.
Okay. All right, well, I asked you to break it down. So is it 2,373.02 just rent, or are there late fees and other things in there?
Your Honor, let me take a look here.
So he went paper shredder?
There's electric bills and rent.
Okay, so I'm gonna ask it again to break it down.
Okay, I have not separately calculated how much the utility charges are. And so that'll take a minute. They do vary from month to month.
So I paid my rent, but then I tore the amount off the check, so you can't see how much the check is for. Mr. Cunningham can't be bothered. He's got something to say, you can tell, but he's got places to be, and this is not one of them.
Like an hour?
What?
It's gonna take like an hour or something?
It'll take however long it takes, Mr. Cunningham.
I was talking to him, this Buchanan, whatever.
I know, but he's just standing here because he does court security. It's not up to him. You can sit at the table.
I can see you too.
Well, we like you by a microphone so that when I ask you questions, we can record
Well,
your
I will get
answers.
up when you ask me a question.
Mr. Cunningham,
What?
you're not gonna disrespect me in my courtroom.
How did I disrespect you?
Keep talking like that.
Like this?
Yeah.
That's crazy.
Mm-hmm.
Keep going.
Huh?
Keep going.
No.
Your Honor, I'm showing that the total, I believe, of the utility bills would be $264.97.
We've got a
So
live
there's
one.
1, 2, 3, 4, and they range in about the $70 range.
Okay.
The rest of it's all just rent.
No late fee.
No late fees on this at all.
Is this a Section 8 property or anything?
No, it's not, Your Honor.
Okay. And the rental rate according to the lease is $850 per month?
Correct.
Okay. All right, Mr. Cunningham, do you dispute that you owe $2,532.77?
Of course,
Well, tell me, why do you dispute that?
because I do, but that little money order that he can't figure out, it was the 850 for this month, for December. The
Okay.
rent's 850 or whatever, it was 850.
Well,
Whatever happened to the money orders happened to the money orders. He can return the junk to me and whatever. I guess it was either $500 money order or $350 money order.
Well, we don't.
I don't know which one it is, but you just return the junk to me and whatever.
Okay.
They'll get that low December junk.
So, but do you owe rent before that?
No,
Well, they're saying $2,532.77. So if the money order was either for $500 or $350, you'd still have a debt.
that's nice.
Well, that's what I'm trying to figure out. Do you dispute that you owe that?
Yes, I don't
Yeah.
dispute this 850 that this money order.
Sure.
I don't
I'm asking
dispute
you about the
that.
rest of it.
Yes, I dispute that.
Based on what? Did you pay it?
No, it's unsanitary. No,
So you're saying the place isn't habitable?
right.
Okay, we're gonna start testimony then. You can have a seat. Mr. Whitty, your first witness.
Your Honor, I call Virginia Hargrove.
He does not want to have a seat.
Just show your oath when you get up the stairs there before you're seated. Okay, raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes.
Louder.
Yes.
Thank you.
Louder.
Have a seat. Okay.
Louder
so
in
you
the
have
back.
to remember, of course, that you have to speak loud enough for me to hear you around the plexiglass, and you have to answer with words that my assistant
Or,
here can
Judge, we
type
could
into
take
the
the
record like yes or
plexiglass
no.
down.
If you say mm-hmm or nod your head, we just can't spell. Okay. Please state your first and last name and spell them both for us.
Virginia Hargrove. My first name is spelled Virginia. My last name is spelled Hargrove.
He says, I'm going to take one of these papers, whatever these are.
Your questions for witness Hargrove.
Thank you, Your Honor. Ms. Hargrove, where are you currently employed?
Fox Land Holdings LLC.
Keeps all his papers in his hat.
In the course of your performance, are you responsible for oversight of various lease rental properties?
Yes.
Are you familiar with the lease between Fox Land Holdings and Jason Cunningham dated June 4th, 2025?
Yes.
And is that for premises located at 205 North Pennsylvania Avenue?
Yes.
Yes.
Your Honor, if I may approach.
Yes.
Wow. Dude will not take a seat. The judge just told him to say, oh, here we go. Here we go. Make yourself comfortable, sir.
Ms. Hargrove, I've handed you what's been marked as Exhibit 1. Do you recognize that document?
Yes.
And can you identify it for me, please?
It is the residential lease agreement between Jason Cunningham and Foxland Holdings LLC.
And if you flip to the end of that document, there's a signature there, and then there are several signatures going forward ahead of that throughout the lease. Have you reviewed those signatures? Could you take a moment to do so?
He tore out the handwritten part of the number, like the $100 and zeros over 100. He tore out that part as well as the number on the check. So the money order is literally not valid. He just gave them the part that says, here's your money order. Oh, man. Christine is, she's antsy as well. I'm getting the same vibes off her as the defendant here in this civil matter.
And was that document signed by Mr. Cunningham?
Yes.
She just needs a bathroom break.
Is this a copy of the lease that was kept in the ordinary course of business for Foxland Holdings?
Yes.
And is this a document you typically rely on in the course of your business?
Yes.
Your Honor, I move admission of Exhibit 1.
Any objection to Exhibit 1?
No.
One's admitted.
Thank you, Your Honor.
Wake up, sir. Your future's being decided. Wake up.
Yes.
Ms. Hargrove, I've handed you what's been marked as Exhibit 2. Do you recognize that document?
Yes.
Is that the notice of equipment that was filed in this case? I think this is the correct notice.
No, this is not the correct one.
I'm sorry, Your Honor. That would be on me.
You tear that up too.
The correct notice of equipment was attached to the complaint in this matter. Is that correct? You would not.
She would not.
Your Honor, my apologies.
This attorney's not quite ready. Didn't break down the fees. Hasn't got his paperwork in order. It's looking good for the defendant. This is the sort of case where you can come in and score an easy win if you'll just engage.
Ms. Hargrove, did there come a point in this case where you filed served Mr. Cunningham with a 7-day notice to terminate the tenancy?
Yes, one was mailed to the address.
And
Christine's like, I've got to sit here and watch this guy for an hour. Oh, didn't know that was an option. I can turn my camera off. Where's that button? What does this one do?
And
boom. There she goes. She gone.
I'll mark this as 2 weeks ahead if I might.
Unacceptable to you?
Yeah, that's right.
And,
this guy's earning all $25 an hour that he bills. This attorney seems a bit uncomfortable in this procedure. There we go. Now it's marked.
let's take a look at that document. Is that the demand for possession that was served at the beginning of this case?
Objection.
Yes, it was.
Objection.
And what date was it served?
September 8th
For non-payment of rent,
for
correct?
non-payment of rent.
And that's your signature?
Yes,
And this is a document you kept in the ordinary course?
yes.
I move for admission Exhibit 2.
Any objection to 2?
No.
2 submitted.
Thank you.
Sorry to bother you, Mr. Cunningham, but Judge has a question. Any objections? No.
Now, Ms. Hargrove, under the lease, was rent owed in the amount of $850 a month?
Yes, it was.
And in the ordinary course of business, does Fox Ranch Holdings generate tenant statements?
Our online software auto generates.
Fair enough. And you're the custodian of those records,
Yes,
so you'd be familiar with them. Is that a yes?
yes.
If I may approach, Your Honor.
Yes.
He keeps folding things up and sticking it in his hat.
I've handed you what's been marked as Exhibit 3. Do you recognize that document?
Yes, I do.
Is that a copy of the current tenant ledger for Mr. Cunningham?
Yes, that is correct.
To the best of your knowledge, is this an accurate account of the records reflecting the charges and payments on his account?
Yes, to the best of my knowledge.
Sure, I move admission of Exhibit 3.
Any objection to 3?
Yeah, I believe that's false, man.
Well, I don't think that's a valid objection. It might go to weight, but not
Well, it
admissibility.
ain't valid.
Exhibit 3 is amended.
Thank you, Your Honor. Now, let's take a look at Exhibit 3. It shows monthly rent charges of $850 a month, correct?
Yes,
And does it show the payments that Foxland Holdings received from Mr. Cunningham?
yes, that is correct.
And in some cases, were those payments made by Volunteers of America?
Yes,
Does it also show electric charges that were imposed under the lease?
yes, it does.
And
He said that he believes
the
it's
lease provides
false.
that the tenant's required to
not
pay
valid.
electrical charges?
Yes,
Let's just find that paragraph in the lease.
He's facing the mic now. Maybe it'll be a little better.
paragraph 21.
So let's take a look at paragraph 21 of Exhibit 1. Let me know when you're there.
So what we have is a tenant who believes he should
And
not
that
owe the
paragraph on the
rent.
start of page 21 says, the beginning of that says, tenant will arrange and pay all charges incurred for the charges as indicated below. Did I read that correctly?
Yes,
And if you turn the page, the first box for electricity is checked, correct?
correct.
He believes he doesn't owe the rent because
So
it's
other than electrical
unsanitary.
charges that are provided for in the lease and rent, are there any other charges on this ledger?
No,
What's the current amount of rent owed as of this time? Based on your ledger.
based on the
What-
overall.
What's the current amount owed at this time?
$2,373.02.
I may approach that.
Another one for the hat. This one's getting folded.
Harper, I'm handing you what's been marked as Exhibit 4. Can you describe that document for me?
Zoink.
It is a money order.
More accurately, is it a photograph of a money order?
It is a photograph of a money order received yesterday.
And who took the photograph?
I took the photograph yesterday when opening the envelope.
Was this, now I see there's like a money order below it and then this money order. Were both of those items in that envelope?
Yes, that is correct.
What's the item below that?
The item below it is a money order for $350 that was applied to the account.
And this other document, is that the entirety of the document that was included in the envelope?
Yes,
Is that anything you can cash?
not to the best of my knowledge.
Could you see an amount on that document?
No,
And that's the condition in which it was when you received it?
yes.
He got the important parts off the money order and sent it in. He might have a case.
Now, does Foxland Holdings maintain a computer system for entry of work orders?
Are you going to motion to admit 4?
I'm sorry, I didn't. Okay. Yeah, Your Honor, I would move for admission of Exhibit 4. Thank you.
Any objection to 4? Where's the money orders there? And then
In the course of its business, does Foxland maintain a system, a computer system for monitoring work orders that are received?
Yes, we do.
And are tenants able to input work orders into that system?
Yes.
And if a tenant calls, say, and asks for service to be done, will then the person taking the call enter that order into the system?
Yes.
So if there are any tenant-generated requests for service, will those be reflected in the system, whether it's by them telling somebody, calling somebody, or putting it in the portal themselves?
Yes.
Has Mr. Cunningham entered anything or called and asked for any to be entered?
If I may approach.
Yes.
You don't have to ask anymore. This is like your witness.
Ms. Hargrove, I'm handing you what's been marked as Exhibit 5. Do you recognize that document?
Yes.
Is that a screenshot from your maintenance network maintenance interface?
That's correct.
And what does it show?
It shows that the tenant did not submit maintenance requests.
Now, through the course of this tenancy, has there been service work done at the premises?
Yes, there has.
And let's kind of go back, and I'd like you to start at the beginning of the tenancy and tell me how maintenance issues arose and how they were addressed, basically with the beginning of the tenancy.
I think he's going to put his head down.
Post-move-in, we scheduled a walkthrough to check on the home and to make sure that there was no maintenance requests needed. Todd Brannick set that up. He ended up posting on the door to notify when he did not hear back, as he told me over the phone. He went and did the initial inspection and found drainage issues. The sink was covered in a brown substance. The carpet was pretty dirty, and anything from the sink to the toilet to the tub in the bathroom had issues. There was a fair amount of standing water in the tub.
Someone's backing
I want to
up.
stop for a minute. Approximately how long after move-in was this?
This was in October, so move-in was back in June, end of June.
Were any of the conditions you're describing present at the time the tenant moved in June?
Not to the best of my knowledge. When I did the walk through the property with him and his caseworker from the VA, everything seemed to be in order, and they passed the unit so that he was able to move in.
So in October, these things were noted. What was done about those things in October?
We scheduled for maintenance to go through and clear the drains. Maintenance also cleaned out the sink. They had to remove feces out of the toilet. They had to try to drain the water in order to clear it. When asked in person, Jimmy Garcia, who did the maintenance, was able to tell me that the drains had been cleared to the best of our knowledge that day we did maintenance, and there didn't appear to be other drainage issues, which were the biggest concern.
Was there any further maintenance done to the unit after that date?
We had to return visit in order to try to clear the drains further down the line. After our previous court date when it was brought to our attention.
So let's just stop for a minute. So there was a time in October when there was service.
Yes.
And this case was filed. Did you receive any communications about the condition of the property between the time of the October issue with the drains and the first hearing in this case?
Again, from Todd Brannick, we went back and visited the property.
But that was after the first hearing, right? I'm asking you, between the time of the October visit and the first hearing when we met with Mr. Cunningham, were there any complaints received by Foxland Holdings regarding any maintenance issues in the unit?
No.
So then let's fast forward to the first hearing we had a few weeks ago. At that time, or at the second hearing, I believe, were there concerns expressed about the condition of the premises by Mr. Cunningham?
Yes.
And what was the response that Foxland Holdings had to the complaints that were received at the first in-person hearing?
I think we're at 6
We
1/2.
scheduled service by 2 different people to go and remedy the issues further.
And what was the result of that service?
It appears that the issues have been remedied. I have not heard otherwise.
What issues were found at that time?
Down the tub, further down the line toward the street, we cleared another clog after the initial one was cleared. Everything else was clear. Then
These are bad
our
pipes.
maintenance person, Dan Harvey, went out and replaced the garbage disposal and checked to make sure the flushing mechanism on the toilet was working properly.
What were the sanitary conditions in the unit at the time?
They were still the same as we had initially found them, if not a little worse.
So generally unsanitary because of the tenant's activities?
Yes.
To the best of your knowledge, were the problems with the drainage system a result of lack of maintenance of the building, or was it a result of tenant activities?
Unknown. There was grease down the kitchen drain. The first maintenance visit showed a lot of hair. The toilet had toilet paper lodged in the pipe work, which had a lot of bends in it. Beyond that, I do not have further knowledge.
To the best of your knowledge, has Foxland Holdings done everything it could do to maintain these premises in a fit and habitable condition?
In terms of clearing the drains and making sure that the toilet is functioning and that the tub is draining, yes.
Is there any other maintenance issue that you're aware of with this unit?
None that we can resolve. That I am aware of.
No, that's not, I mean, are you aware of any other habitability issues, whether they're resolvable or not?
Like bugs?
The unit has what appears to be mud on the walls, dirt in the carpets, film on the toilet and the sink and in the tub.
Are you describing basic housekeeping issues then?
Yes.
Those wouldn't be Foxland's responsibility, correct? That's a tenant responsibility?
Correct.
When we get to the issue of habitability, what I would like you to do is address issues that are the landlord's responsibility. To the best of your knowledge, has the landlord done everything it's required to do under the lease to keep the premises
The
habitable?
water works.
Yes.
No bugs.
No further
electrical connectors.
Mr.
are
Cunningham,
all there.
and you never moved for admission of Exhibit 5.
Oh, I'm sorry, I would do that at this time. My apologies.
Any
It's too late.
objection to Exhibit 5?
Okay, man.
Mr. Cunningham, this is your opportunity to ask this witness questions. It's not your turn to testify yet. We'll get to that shortly. But are there things that we should ask this witness that she hasn't talked about?
Yeah, I got one question.
Okay, go ahead and ask her.
Why, when you sent me some mail from your little office about the unsanitary conditions in the bathroom and in the kitchen and stuff, that was my first day there, like June 6th. My first day there.
Well,
those
ask
things-
her a question.
I'm about to ask.
Ask a question.
I don't have no questions, man. I ain't got no questions.
When the unit was rented in June, had it had a pre-occupancy cleaning?
Yes.
Okay. What was the condition of the carpet then?
It was newly installed.
The carpet was new at move-in?
Yes, Your Honor.
I noticed on the ledger that at the beginning it has a cleaning fee of $200. What's that for?
That's used at the end of tenancy because for Michigan law, we're not able to, if we're charging a fee that's non-refundable, it has to be called a fee. So that's used at the end of tenancy to clean the unit.
Okay, so that's not for the beginning.
No, ma'am.
Do you have your tenants complete a move-in checklist of any issues with the property?
No, ma'am.
Is that normal? They just don't do that at all?
It is hit or miss. A lot of people return them, some don't.
Mr. Cunningham make any complaints about the condition of the property in June
No.
The judge is doing the work for him.
or July?
No.
Why was it October when the walkthrough occurred?
We started a new program internally to make sure that maintenance was being kept up on new move-ins, to make sure what the condition of the property was for new tenants.
Okay, I'm not convinced this isn't like a slumlord situation.
Mr. Cunningham, do you have any questions for her now? Mr. Whitty, any redirect?
No redirect, Your Honor.
Makes sense.
All right, you're done, witness. Thank you.
Okay, Mr. Whitty, any different or additional witnesses?
All right, I call Jimmy Garcia.
Jimmy Garcia.
Yeah. Do you swear or affirm the testimony you're about to give will be the truth under penalty of perjury?
Yes.
Okay, have a seat. Please remember to keep your voice up so I can hear you around the plexiglass and answer with words we can type into the record like yes or no. If you say or nod your head, we cannot spell it. Please state your first and last name and then spell them both.
Jimmy Garcia.
Spell them both.
Oh, I'm sorry. Jimmygarcia.
Spell them both. Do you not
Your
understand?
questions for witness Garcia.
Thank you, Your Honor. Mr. Garcia, how are you currently employed?
Through Fox Lane Holdings as a maintenance tech.
And in that capacity, did you have occasion to visit the premises at 205 North Pennsylvania Avenue, Unit Number 1?
Yes, sir.
And when was that?
In October, I'm not sure exactly the date, but 8 a.m. was the time.
And why did you visit the premises?
I was instructed to clear the main drains because anything that was holding water wasn't flushing or wasn't draining.
And when you arrived there, can you describe what you found?
I normally just go right to what the issue is. If it's in the bedroom, I go right to the bedroom. So I went right to the kitchen, and I could see that the water was being held on both sides of the sink. The bathroom.
Let's start with that then. Why don't you tell me what you did with regard to the sink and what you learned?
Okay, well, when I went to the sink, I could see that we were both filled up, and I can't see the drain. So I always go to the basement or wherever the main drains are. That one had a basement. It had two main drains, one a lot closer to the water supply than the other. So I started with the farthest one. I opened that up and there was nothing there. There was no water or anything.
You're talking about the clean out in the basement?
Clean out in the basement.
And how many clean outs did you inspect in the basement?
2.
And both of those were dry?
Yes, sir. I opened them up and there was nothing coming out, which told me that the plug was higher, closer to whatever I was working with.
So then did you return to the sink?
Yes, sir.
And what did you find?
I started taking it apart as soon as I had to use my vacuum to vacuum the water out of the sink. Okay. Once I got to the bottom of the sink, I could see both drains. That told me that there was nothing there. So I took the plumbing apart underneath the cabinet. Since I took the trap off, a little bit of water came out, but the trap itself was holding grease from one side to the other. It's a little curved. It's about 4 inches and about 2 inches in diameter.
You can't pour grease down your sink.
With grease.
Cooking grease, basically. So presumably you cleared that and reinstalled the plumbing?
Yes, sir.
What about the bathroom tub? What did you find there?
The bathroom tub itself was completely full of water. There is a mechanism called the overflow cap. What that's used for is if the water level gets too high to the bathroom, it goes into there without you having to pull a plug. It'll automatically drain the water out. That was above, the water was above that. So I had to take again a vacuum and vacuum the water out low enough to get to the overflow cap. I took the overflow cap out, used my drill auger, and ran it about 3 to 4 feet down into the plumbing. And I got a stopping point. When I pulled it back out, the hair came out, the water started to drain. I let it go until it completely drained out. I put the plumbing back together. I cleaned the bathroom, the tub as best I could. It was pretty bad. And then after that, I went to the next, which was the toilet.
Tell me what you determined was going on with the toilet.
Unfortunately, the toilet was not From what I could see, it was full. It was not working, but it had still been being used. I had to take gloves and a plastic bag to get the feces out so I can get down to the drain. Again, I used my auger to run it down there, and nothing came back out. What happened on that one was actually whatever was in it, I pushed it through. Okay, and as soon as I pushed it through, the rest of the water just went down. Again, I flushed it several times to make sure that it was working. I cleaned it and took pictures.
And in all of those cases, these are basically situations that were clogs as a result of usage of the plumbing, correct?
Correct.
Wallflower, thank you. You're an OG. 34
Few
months.
questions for Mr. Garcia.
May I say something?
You have to be responsive to a question.
No.
Okay. So when you left, that was a date in October, you said, correct?
Yes, ma'am.
And everything was working properly at that point?
When I left, yes, ma'am, and it was also clean.
Did you receive any additional complaints about the plumbing at that location?
No, ma'am, not personally.
Okay. Did you return to that property to clear out drains at a subsequent date?
Negative.
Negative, Your Honor.
Mr. Whitty, any additional questions based on that?
No further questions, Your Honor.
Mr. Garcia, you may sit down.
Okay.
Your son just smeared feces all over my bathroom.
Okay, then it becomes your opportunity. Mr. Cunningham, would you like to testify?
No. I ain't got nothing to say, man. I want to get cursed out by you again.
That's more with you not being polite,
Yeah, we know.
disrespectful. Okay. You don't want to talk about the issues with the property?
No, because I don't want to be unpolite and disrespectful with everything else you say I am.
Okay, well, I've given you the opportunity. I've asked you twice now. All right, then I guess we're going to wrap this up. Mr. Whitty, do you want to make argument?
Your Honor, I think that it's pretty clear that the rent owed as requested. We request entry of the judgment.
Mr. Cunningham, would you like to make any argument?
No, I ain't got no argument. I got a question though.
Uh-huh.
Where do I go to pay your little court fee?
What court?
Is it in this building that I pay for the little court, this 160 or whatever it is? The court.
It goes to the plaintiff because they've already paid. So you have to reimburse them for what it costs them to file the
Okay,
case.
whatever. Cool.
That's what the court
Cool.
fee is.
Okay. Yeah.
Okay, thank you. Today, we're here for a non-payment of rent case. The court has received several exhibits from plaintiff. One is a lease showing the amount of $850 per month. Also, there's a provision in here for the tenant to pay utilities. I will say it isn't the most clear provision because based on the, let's see, it says tenant pays for electricity. It's just not clear. It doesn't seem to say the tenant has to put it in their own name, so they must be running it through the landlord.
It's in my name.
There's the issue of the money order. Based on what Mr. Cunningham said before we begin taking testimony, I'm going to guess the broken money order is supposed to be for $500. There was no testimony that no work orders were ever requested by the tenant. There's testimony about repairs being made at the property when they were apparently located by plaintiff without the defendant complaining about the condition of the property, and efforts were made to restore the property. Based on that, I find that plaintiff is owed the rent. The ledger shows that rent was it was fully paid in up through July. August rent wasn't paid. September rent wasn't initially paid. In October, there were rent checks suddenly coming in. I'm not sure what changed in October. No rent was paid in November. And in December, there was a $350 credit, which even if Mr. Cunningham says that was for December rent, it goes to the older rent that was owed, which was, there was already an outstanding balance at that time. So I'm going to order that rent to retain is $2,373.02. The court costs as requested
$160
by plaintiff are the $159.75. I'm going to order that the broken money order also be returned to Mr. Cunningham so he can call Fidelity and see if they'll issue him a new one or something, because that's $500 Mr. Cunningham needs back. And then the writ date today will be 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, December 26th.
Mr. Cunningham, what's
Your Honor, I
your...
have a judgment if I may approach.
Did you write the provision about the money order on there?
I did.
Is that for you?
Wow. His attitude is... Oh, yeah, that's how he answered the judge. And mad props to the judge.
I'm signing this
She could have snapped
judgment.
him and held him in contempt. And she,
Copy will be given
that's a tool
to each of you right now, and you'll be on your way.
Thank you.
You can put it in your hat, sir.
Can I leave now?
When she hands you your copy, she's gonna hand it to you right now and you can walk out.
It's going in the hat. He gone. He gone. All right.
On the record in Credit Corp Solutions, Inc. versus Christine Detavanage, 2506433GC.
I think we're going to bail.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
You are Christine Detavanage, joining me by video?
Christine Detavanage, yes.
Okay. Today is the date for pretrial in this matter, and the parties did take the opportunity to meet. Were you able to either resolve the case or come up with a way to get the case ready for trial?
The parties agreed to 60 days for discovery, Your Honor. We were unable to resolve it at this point in time.
Okay, so you're going to file a joint pretrial statement?
Okay.
That was a question.
Okay, so do you need to talk further about what needs to go on your pretrial statement?
Yes, I'm sorry. I was not prepared for that. If you can put us back in the breakout room, I'd appreciate it.
They sat there this whole time, and they're not ready. Oops. Judge is like, you know what comes next. All right, going back to...
Janet Zahn and Megan Stambach.
We'll turn that off for a minute. Let's see who our different courts are. Chisholm has what is it? Royal Oaks is off right now. Let's see, it looks like in the bottom right hand corner we've got Judge Cedric Simpson giving his regular PowerPoint presentation notice to all Zoom users that's going on. Let's see, Judge Shackelford has stepped off the bench. This is the end of the rights as required by the Michigan Supreme Court. Let's see, I think we're going to go, let's go check in on Simpson. Let's see, I think that's box 4, right? Zoop, whoop. There we go. And he is an 8, I think. Oh, the audio's weird on this channel for some reason. I'll fix it. Oh, yeah, we've got people here. Whoa, we got people. We've got Hollywood Squares going on. There's got to be a soft sit in here somewhere.
And we can get started. Craig Bosley versus
it's not
Kimberly
Simpson. I was completely wrong. This Judge Goggins.
Okay, Mr. Sabo on that matter. Anybody?
7th District Court.
Nobody on that matter? Dismiss that matter.
Clean up the audio a little bit. Holy cow, who do we have here?
How about TLG Real Investors versus All Occupants?
Attorney Sabo is driving.
Morning,
right
Your
now.
Honor. Robert Iggerson on behalf of the plaintiff, P33035. I apologize. For some reason, my video is not working, but I can hear the court, and hopefully the court can hear me.
Yeah, that works. That's fine, Mr. Ingerson.
Thank you.
Let's see. Do you have proof of service in this matter? Do I have anybody? It says all occupants, and this is for. Oh, here it is. This is property at 11354 Berkshire Drive, Clio, Michigan.
Yeah, it's a recover possession only, no money judgment request. We'd ask for the entry of a default judgment of possession with an eviction order to issue after December 26, 2025.
Okay, let's see. I do have just quit, recover property.
There is a second mailing as well.
Oh, in fact, that's what I was going to look for. Yep, in fact, I found it. Thank you. Find the files in order. Grant a default judgment on that matter.
May I email or fax that in?
Email would be great. And I don't know if you have my staff's
No,
email.
please tell me.
Sure.
Can I
It's
fax that in?
as if one word, J as in Janet, JDRI.
I don't need his email address, and we don't need to send him email either. Even though it's on public record, we're going to go ahead and give him his space and not invade his inbox.
J is in jump. D is in Rob.
He's spelling it out slowly. We might bail. It sounds like this is more landlord-tenant stuff. Let's see if we can check out Judge Simpson. Not Simpson, but Judge Boyd. Let's go to Judge Boyd.
That's being Odyssey.
Well, it's about to pop up now, so it's just being Odyssey.
That sounds like Odyssey.
She has a new purse today.
All right,
I've always liked pine cones in a floral display.
what is happening with this case?
On this one, Judge, the state, I spoke to the state, there's supposed to be a phone dump from the victim's phone that they're supposed to get to me. They haven't gotten it yet, so they don't even have it to give to me. That's what we're waiting on. We've only had really one setting before this, and that was on the motion for bond reduction. We ended up withdrawing that motion, we ended up holding that hearing because the state and I agreed. We got that signed. He is now out, and we're starting the beginning of the handling the case, Judge.
All right, so everyone please lower your voices.
There's a
Other
huge
than the
cowboy hat in
discovery
there.
for the phone, is there anything else?
I don't believe so, Judge. Not to my knowledge, but obviously once I get the phone.
And is there CPS records?
I don't believe as of right now there
Greener's
are.
triggered the
I don't believe so in this case.
Okay.
Just in case we'll look into that. Well,
Any school records that are needed?
I'm guessing that
Any
mask is
therapy
to
records?
hide his identity.
That I'm not aware of any therapy that she's ever went to.
All right, I need a discovery date. End of January. All right, we'll come back on January 26th for discovery. Once you sign the reset form, you'll be excused.
Thanks so
All right,
much.
just have a seat. You're welcome.
Thank you, Judge.
Anyone else ready?
Page 61 down.
Logan McBride.
Present, Judge. Morning.
Good morning. How's it going?
Take your hand out of your pocket.
Get your hand
Oh,
out
hands
of your
out of
pocket.
pockets, deputies. All right.
Oh, the deputy
So,
has the hat on. He
On
can
this
wear a hat
case,
in
where are
court.
we on discovery?
I just got hired 6 days ago. There was no e-discovery at all. I had a front prosecutor, storage
This is not
drive.
the case you're looking
He's
for.
hoping to maybe have it ready maybe tomorrow because I'm leaving town for the rest of the year on Thursday.
Okay.
And if I don't get it tomorrow, then I won't get it till after January.
Where are you
All right, Ms. Ferguson, set this for discovery and for the state to tender an offer at the end of January.
Why does he look
All
like
right,
he's
thank
wearing
you.
a
Once
lab
you sign
coat
the
over a
reset form, you're
t-shirt?
excused.
Thank you, Judge.
You're welcome.
Oh,
Safe
because he
travels.
is.
Louisiana.
Yay, which part?
You know, we're going to start in Lake Charles to do the Gordon Ramsay Steakhouse on my son's birthday.
Hey.
In Lake Charles. But then we're going to Florida. In-laws are there.
Enjoy, but be safe.
Have a great year, Judge.
All right, you too. Who's next?
Page 5, fifth one down.
Is that a Texas Ranger there with the hat on?
Basilio Carrillo.
They just told me that.
We are keeping an eye out for Burnett Circuit Court, Branch 1. Might be jumped to there in just a
Hey,
minute.
you're gonna lose your wallet like that.
Thank you.
You're welcome. That would be a shame to have that happen this
'Cause then
close.
how would you pay your court fees?
All right, on this case, today is your plea deadline date.
Judge, we are unable to resolve this by plea bargain and are requesting a trial.
All right, how long do you expect this trial? A week?
With this type of charges.
A week or 4 days?
4 days.
All right, Ms. Ferguson, on your jury trial date.
March 20.
All right, your jury trial date is going to be March 24th. Your plea deadline date has expired. The court will not consider any plea bargain agreements in this case without good cause. Otherwise, you'll plea open to the court. Do you understand? Great, thank you. Just have a seat. Your attorney will bring the resets form, and I need an acknowledgement of discovery completed.
Do we know that's not, I'll.
Okay, all right, thank you.
I'm still stuck on that bailiff's hat. That's just, I mean, you normally remove your hat when you go to court, but he's just got like a giant one.
Anyone
a giant
else
old
ready?
Stetson.
That's it at the center.
All right, thank you. Alfonso Cabanas.
Yes, Judge.
Kimbers, Ohio. What's happening? Oh, March 24th. Now the judge just disappeared. Let me check our Burnett court. She's not quite here yet. Let's see. Let's go to our 4 box and see who's up. Anybody? Got Judge Boyd in 2 places. That's no good.
There's one fine lawyer right here.
Yes.
He convinced his innocent, guilty guy to take the deal.
Judge, you'll
Okay.
be 5 minutes.
Ah, okay.
Singing your praises to himself.
Bernie has a criminal calendar going. Don't see many sob sits with Judge McBurney for some reason. We spent a lot of time in his court.
We'll play a little
yesterday.
game. But I just, I wish to. I have one off-docket motion that's agreed to by the state. And then on 10 O'Hara, they have a daycare.
Okay, we might have to go to Royal Oaks.
We're gonna have Miss Anna.
Get some arts, beats, and eats stuff. That's 44th district, right? Yep. We're going to go down here to Royal Oaks. Judge is muted right now. Worst festival ever, I guess. Arts, Beats, and Eats is still terrorizing the local parking community, for sure. This is how they make their big bucks. It's not through festival attendees and sales and tax. No. It's the tickets. It's the parking tickets downtown during the festival, which I think runs 6 months. Runs for 6 months. Correct me if I'm wrong. It might be 5. Now it will be the holiday market tickets. There's always some reason why the parking meters are not for your use. Is it beats or beats? I think it's supposed to be music. So art, music, and food is basically what it's supposed to be. Arts, beats, and eats. Arts, beats, and parking fines. There are 5 things. Bears beats Battlestar Galactica. Yes, I like the Office reference, always appropriate. Judge is reviewing something. In my head, it's beets. I'm okay with that. I would be okay with it being about sugar beets as well. Love the holiday market. Where do you park during the holiday market? Just curious. You don't have to out yourself in case it's breaking the law, but parks, beats, and cheats. There, that also applies. Identity theft is not. You know what I got? I got a letter the other day from an insurance provider that I had for about 3 months. It was terrible insurance. Just not the company was bad. I'm not trying to say that Blue Cross and Blue Shield is bad altogether, but I only had them for 3 months, and the plan I was on was probably the most terrible insurance plan you could ever be on. I don't think we ever used the insurance. Like I paid through my work. I paid for access. And I just got a letter that said, hey, we're just letting you know, as required by the law, that your data was stolen. And apparently someone had access to our system from October 14th of 2023 to January, I think it was 19th of 2024, at which point we caught it and found it and fixed the hole. And we're just writing to tell you now, here at the close of 2005, that your information was included in that leak. I'm like, I appreciate you notifying me. I just want to know why there was the gap. If it was stolen in 2023, you found out in 2024, and then you waited all that year and most of the next to contact me and tell me, by the way, you might want to monitor your credit because we gave away everything. Everything. Oh. I said 20 years ago. Sorry. It seems like 20 years had passed. And if they knew it, they fixed the problem, and they knew the files that had been lost. They just said there was just so much. It took us 2 years to go through and identify that yours was actually in there. All I can do is hope that where's Burnett? Let's go here. Hang on. Why do we not have audio? 3, we need audio.
Person in custody with counsel Eugene Harrington. We're set today in this matter for the sentencing portion of this case. Mr. Winquist pled guilty on September 8th, 2025 to count 2, 3, or excuse me.
Uh-oh.
Yes, to count 1 amended to second reckless injury with a firearm as a domestic enhancer. Count 2, 3, 6, 7, and 8.
I just noticed they have the child
The
lock
court
fence
ordered a
up for the
pre-sentence
gate.
investigation report. The court has received and reviewed the report. And in my review,
I think that's a new addition.
and in my knowledge of the facts of the case, as they specifically relate to Mr. Winquist, the court did not see any mistakes or need for corrections. But again, the parties, the council, have better information with the specifics. Mr. Schmidt, did you receive and review the pre-sentence investigation report?
I've received it. I've reviewed it. I have no corrections.
Mr. Harrington.
I received it or reviewed it. I went through the document with Mr. Winquist. We disagree with some of the characterizations, but we don't disagree with the facts in large part.
All right, thank you. Mr. Winquist, you agree with what your counsel has just stated?
Yes, Your Honor.
Okay. All right, before we move to arguments from the attorneys, I'm going to have the victim impact statements. Ms. Bauer, please let me know the first individual who will be speaking.
Pam?
What is Pam's last name?
Brew?
Can you spell that, please?
B-R-E-U-H-L.
Have a seat right there.
All right.
Oops, sorry.
And for the record, please state your relation to this case.
My relationship to Christina is her mother.
All right, you may begin.
Well, I mean, really, what can I say? I mean, Christina has been shot. She's had to go to the doctor several times during the month. I think it was, don't quote me on this, but I think it was like 34 times out of 30 days that she was at the doctor. It's caused a huge hardship within our family. I mean, really, what can you say? My daughter's been shot. Yeah, she may look normal, but she's not normal inside. Her cognitive ability is not there. And then you expect her to live a life, and the rest of us to live that life as well. I mean, it is what it is. I mean, the doctor's reports and everything has been there, has showed everything. She's not okay. And, you know, let's get back to where, you know, the very beginning of really what happened and what's gone on. And that's what I expect the council to do. Thank you.
Thank you.
Any more witnesses? Yes.
Deb is next.
Spell the name.
What is your last name?
Kelly, K-E-L-L-Y.
All right, and please state your relation to this case, and it looks like you are going to read something.
These are just my notes.
Okay,
for the most
and I'm
part.
fine with that. If you read something, just please make sure to read it slowly so the court reporter can take it all down, okay?
I will do that.
All right,
Thank you.
thank you.
Thank you.
I didn't get her last name.
Kelly, K-E-L-L-E-Y.
K-E-L-L-Y.
Oh, Y, sorry, I wrote
That's
E-Y.
okay.
I apologize.
That's okay. I am a friend of the family, also Christina's advocate. I have been here since March of 24, or sorry, March of 25 is when I was asked to kind of step in and help with the family. Christina did not have the ability to schedule appointments, drive anywhere. So they needed somebody to kind of coordinate all of this, and I stepped in and took that role. During the time that I've gotten to know Christina, I just love the girl. She's just a sweetheart, but I didn't know her before. So all I can say is how I can perceive her now, but she's had so many doctor visits. We had to establish primary care because she had to leave her home in Cambridge, which she lost because she didn't have any employment. So she left her home in Grantsburg and moved to Cambridge so that her son could stay with her sister. She's been to neurology. She has a TBI. She has seizures almost weekly. She had a brain bleed, which resulted in having a coil implanted. We've had psychological testing, behavioral psych testing. She's been determined that she has moderate to severe memory issues and moderate neurocognitive disorders secondary to the TBI. She's been to cardiology. She's had at least 4 cosmetic surgeries to repair the injury to the scalp. She has 2 more coming. The surgeon did make a comment that it was like putting Humpty Dumpty back together again. So that was kind of interesting because it was such a mess. The orthopedic, she has injuries to her neck and her lower back. She is now using a cane and a walker, depending on where she is. She's supposed to have a sleep study done, but she's got some trauma with that for fear of being away and being around others. She has biweekly therapy sessions for trauma PTSD, anxiety, depression, sleep issues. Excuse me, she has 90% hearing loss, both hearing aids in both ears, and all of this is a result of the injury on May 31st. She had left Grantsburg, the place that she knew as home. She lived with her sister for a while, and her son lived with her other sister. They weren't able to be together. The home that she lost was the home that she had with her prior husband, who has since passed away. So this home meant a lot to Christina and the boys, and it's now gone. And to clean up the house, because of the damage that was done, just the biohazard cleanup alone was $28,000. That does not include repairing of the subfloor, new carpet, new sheetrock, new appliances, new flooring. That's above and beyond. Her home in Grantsburg had been robbed many times to the tune of $18,000 plus, and those charges are still pending. And that's because she was unable to be at the home. Because of the result in the loss of the home, she's incurred about $20,000 in attorney's fees.
This guy's
which
mugshot picture is
we're not sure
something
how those are
else.
going to get paid. Right now, her only source of income is working very part-time. And her deceased husband has a small pension.
That's how he looked when he was
Otherwise, that
arrested.
is her only source of income. We've applied for Social Security disability. We've initially been denied, but we are in the process of appealing for that. She's been subject to some online harassment by the defendant's ex-wife. And also, his aunt apparently made an appointment. We want to make sure that this is known to him too, and his mother. His aunt made an appointment to see Christina. She is a cosmetologist at the salon. Was very intrusive in a lot of the questions that were asked. Christina was just being very polite and very, didn't give a whole lot of information. And then as she was leaving, she turned to Christina and said, "By the way, I'm Mike's aunt," and left. That caused some serious trauma for her. No matter what happens, Mr. Winquist will be able to leave at one point and lead a relatively normal life. Christina's life has been irrevocably changed. There will be no living normal for her. She has PTSD. She has flashbacks. She has blackouts. She is fearful of being in public, or especially being around men. Her and Donovan they're doing good based on the circumstances here, but life is not normal. They're doing good, meaning that they're here physically as to what could have happened. That's all I have for now, and thank you for your time. I appreciate that.
Thank you, Ms. Kelly.
He used a shotgun to shoot her and himself after he thought she was dead. He was drunk. He says he didn't know why he shot. He just woke up and blasted. That's what he said.
Donovan, what you can either tell me your last name or you can give me an initial.
Check.
Can you-
CZECH.
Okay. And you are the victim's son?
Yes.
All right. What would you like me to know? And I'm going to say you sound a little spoken, which is okay, but can you speak into the microphone and talk as loudly as you can and try and enunciate your words so I can hear them and so my court reporter can hear them?
Yes.
Okay.
So, like, I don't really understand why it's not child endangerment is added to it. Because if the gun was not jammed, I know for sure he would have came after me because I was still in the house. I was behind, like, one of these walls right here. I was behind one of those.
And you're pointing to the jury box?
Well, like,
So it was that high?
no. So our stairs are on the other side, and he was over here in our house by the fridge. He could have easily, because there's no basement door to get out. So he could have easily trapped me in the basement and shot me right there. But thankfully, God saved me and my mom. For the whole night, I didn't even know she was alive or dead because they didn't give any information. And then I had to stay away from my mom 3 months. 3 months. Because she had to heal. And I was living at my aunt at the time. We saw her for the first couple of days, saw her breathing tube down her mouth. She could not talk for the rest of the week after she got shot. And then the next week, she was a little bit better. And then we saw her heal and heal. But then she said, I can't hear you, Donovan. You need to speak up. And then they're thinking about that she won't even remember me ever again. But that was proven that she could remember me. It was just a hard time. We're struggling to pay bills, all because of this happened. And then we get robbed like a couple nights after. And then, I don't know. And then we expect him to come back to the same community, live his life, a normal life. He can do whatever he wants as soon as he gets out. But me and my mom struggle to do stuff that we want to do because it depends how her legs feel, depends how she feels that day. And sometimes she gets so scared at night that she comes in my room, makes sure I'm still there, and checks on me. That's how bad it is. That's how bad her PTSD is. I'm seeing weekly therapy with my PTSD because whenever she has a man over, I have to tense up or I have to get involved. It's just we can't live our life normal again. We can't trust any man that's in our house because we don't know what they're gonna do. And yeah.
Thank you, Donovan.
Yeah.
Guess there's another way around the wall.
All right, and you can either state your name for the record or you can just use your initials.
Christina Fickbaum.
All right. And I'm going to say the same thing to Donovan. Please speak into the microphone just so I can make sure that I hear everything and my court reporter can too, okay?
Okay.
This guy has a prior where he was
At
arrested
any
at a
time you
Packers
need me to
game.
turn up the system so you can hear better, if you're missing something,
Lambeau
just
Field.
raise your hand and then I'll know that I need to turn up our audio system, okay?
Okay.
He was too drunk. A bartender wouldn't serve him. He became
You may
rowdy.
start whenever.
You know, it took me a long time to decide what I was going to say, what I wasn't going to say, because.
And I'm so sorry to interrupt, but can you just, I know that this is, that you're in court and your anxiety is probably really high, but can you just speak a little slower too?
Sure. I struggle with it just for the simple fact that, you know, a lot of things I don't remember. And anytime that I think about Mike, everything just goes blank. I'm definitely nervous about what I should say or what I shouldn't say for fear of what will happen once he gets out, because I'm unable to file a restraining order at that time. But, you know, one of the big things that, you know, has not been brought up at all is Mike was shot. And I took care of him throughout the whole entire time. I didn't have that. You know, like they say, my life is not the same. My whole family's been impacted by this. And I feel bad because I'm like a burden. You know, I always tell people it's like in reference of when you blow out candles on birthday cake, that's how fast my life was gone. He didn't kill me, but my life left. And, you know, the other thing too that's pretty hard is that he could have very well taken another parent for my children. And the thought of that for them is just unbearable. And I'm not the same. I mean, people keep telling me I'm not the same. I don't feel the same. I guess, Debbie, can you?
Yeah. I want to get one thing that I know she wants me to.
Is that all you would like to say today?
She's gonna have Debbie finish for her.
Right. Okay, and that's totally appropriate and fine. If you are going to read something, please read it slowly.
I will.
Thank you.
Okay. The one thing that bothers all of us here, I think, is there has never been an attempt for any apology. There has never been any show of remorse. And the fact that they're saying that he didn't really know what happened, pardon my French, he's full of shit. And I apologize for that. There was one thing that Christina came across that I wanted to read as though I'm Christina. You were not my partner. You were my punishment. You didn't love me. You drained me. And yet I called it romance. You didn't hold me. You caged me. And I mistook the bars for a warm embrace. You weren't my partner in life. You were the tax I paid for ignoring my worth. I prayed for love, and life handed me a lesson in scars. That wasn't fate, it was a mirror. It wasn't chosen. I wasn't chosen. I was targeted. My kindness made me a canvas for your cruelty, and my silence gave you power. You broke things in me you had no right to touch. I kept trying to heal with the same hands that hurt me. You didn't walk beside me, you dragged me. You weren't building a future, I was surviving a sentence. You were a storm pretending to be a shelter. You called it passion, but it was punishment. I watered dead things. I stitched red flags into rose bouquets. You weren't a lesson. You were a warning, and I just refused to listen. So tell me this, was that love or was it self-destruction wrapped in longing? Don't lie to yourself. And the worst part, I loved you deeply, but not anymore, not anymore. Thank you.
I stitched red flags into rose bouquets.
Ms. Bickbaum, are you sure that you don't have anything else to say? All right, thank you. Ms. Bauer, is that all of the statements?
Yes, Your Honor. I'm a actually. Christy Madsen is a friend and she wants to speak.
Any objection? A close friend?
Well, did she submit a statement to the Department of Corrections in the PSI process?
I don't know.
No,
I don't recall who all did.
she did not.
She did not.
I don't have any objections.
Mr. Winquist, any objections? Nope. Okay. You may provide a statement.
Wow.
I didn't catch the name. I'm sorry, Judge.
Krista Matson.
KRISTAMATTSON.
All right, you may begin.
I'm here on behalf of Christina Fickbaum. She is actually not very much able to speak for herself. And the one statement that I would like to leave the court with more than anything is that she is asking for the highest amount of sentencing that can be provided under what he has already said guilty to. And that is it.
The maximum penalty. He was charged with first degree
All right.
attempted first
Is
degree
that all,
homicide.
Ms. Bauer?
7 counts of possession of a firearm by a felon.
Okay, I'm now going to turn to the attorneys for arguments. Mr. Schmidt.
Sorry.
Mr. Schmidt.
I do have cough drops up here if you would like.
I'm good. I just swallowed wrong right at the part where I need to speak. As the court recalls, the state is free to argue in the sentence, except that the second-degree reckless with the dangerous weapon will be concurrent to the felon in possession of firearm associated with the firearm used in it. And that will be consecutive to the felon in possession of firearm charges associated with the guns in the closet, which will be concurrent with each other. That means the state is therefore capped at 12.5 years initial confinement and 5 years extended supervision on the first cluster, and 5 years initial confinement, 5 years extended supervision on the second. Totals about a 27.5 year sentence of imprisonment, which is comparable to what DOC recommended, which was a range of between 11.5 in and 18.5 in, aggregating all their consecutive counts, and 6 to 7 out, aggregating all their ESs that they recommended. The state's recommendation.
I think that's incorrect. That's not how I added up what the DOC's recommendation was. I believe for count 1, it was 5.5 to 6.5 in. And then 2 to 3 for all other counts, consecutive, all consecutive.
Yes, I added them up, and that's what I added up to if you run them all consecutive. Unless if I read that wrong.
They're all consecutive. Okay, consisting of, oh, they did 1 to 2 initial. That's right. Okay.
I
wrote down 2 to 3, and it's 1 to 2.
Yeah.
Judge, my understanding is the Department of Corrections recommended essentially 16.5 years.
Well, they gave a range is the thing. So I was including the range.
If you go to the maximum of the range, it's 16.5 years.
Oh. Well, regardless, my recommendation is going to be the upper end of what I'm capped at. It's going to be 17.5 in and 10 out, which is relatively close to what DOC recommended. In Wisconsin, for any case, for any sentence, the court must always consider probation first. It must consider something called the McCleary-Gallion factors, which is the gravity of the offense, the character of the offender, and the need to protect the public. When we actually argue this in practice, we usually break down those more abstract legal terms, those 3, into more specific things like deterrence, punishment, incapacitation, rehabilitation. Those subcategories of those factors are easier to break apart and discuss and apply facts to than something general and big like protection of the public. Those factors and sub-factors, I believe, can be generally split into 2 categories. Factors are supposed to be predictive of behavior, related to the character of the offender and the need to protect the public. Those are things like specific deterrence, rehabilitation, incapacitation. Those are all things that the judge has to largely look at the facts and predict what's going to happen in the future. What is the lowest sentence that will specifically deter this offender from doing this again? What is the sentence that will rehabilitate this offender in the future so it won't happen again? If it's not possible to fashion a sentence that could accomplish those things, do we simply incapacitate the offender with a long sentence? That's what I mean by predictive factors. The other factors have to do with largely what we might call accountability or more broadly public policy. These are punishment, general deterrence, and not depreciating the seriousness of the offense. These are factors that have less to do with the defendant as an individual and more to do with the nature of the offense and its relation to the community. The public needs to know how different behaviors will be generally deterred from other people who would do them in the future. They need to know that offenses involving particularly bad morals or bad mens rea or bad impact to the victim will have that cause higher social and victim costs will have higher penalties to satisfy the general social and psychological need for punishment and to not depreciate the seriousness of the offense by doing something that would offend and depreciate. In both those regards, this case is largely fact specific. So I'm going to quickly overview the facts of this case as it relates to that. This is a case where Michael Winquist shot Christina Fickbaum in the head with a shotgun, not outside, not during like a hunting incident or cleaning a weapon, but for no reason at all. It was done in the kitchen, and there was no danger there. There was no home invader. There was nothing like that. In the days leading up to the offense, there were no indications that this was something that was predictable that was going to happen. Analysis of the phones of both of them showed their relationship was good. According to the child, according to the child who was there in the home, there was no argument in the immediate lead up to it. There was an argument earlier in the day in which they were arguing about money related to the child's father owing them money and a need to possibly engage in civil suit for that. What happened is at some point in the day, Michael Winquist, who had not been sleeping for days, had been drinking constantly for days, was on what you might call a bender, suddenly was heard by the child who was in the basement, suddenly wake up, crashing around the bedroom, stumble to the kitchen. He heard a gunshot. His first thought was, well, Michael Winquist often will like shoot like squirrels and varmint and things like that, until he heard a body drop. And then he went up and found the image of Michael Winquist in front of his mom with a gun with her bloody on the floor. He fled, and when he was outside, he had to watch Michael Winquist shoot himself. He wasn't sure if Winquist was dead or not. Later on, he would go back in and remove the firearm. Michael Winquist was there ineffectually doing some sort of care to the head wound while mumbling something about dreaming. The victim, Christina Fickbaum, miraculously survived. She survived a gunshot wound to the head. In fact, she walked herself out of the building to EMS outside.
That is incredible.
The injury that she really was inflicted with wouldn't become apparent until later. In fact, if you watched her right after the incident in the hospital, you wouldn't detect any sort of impairment in how she's interacting at all. None of the cognitive or neurological issues that you've heard from the victim statements today. That was an injury that has worsened and festered and grown and gets worse with time after the injury was inflicted, the initial gunshot. At that point, law enforcement asked her the question, what happened? And she couldn't remember for obvious reasons. She was shot in the head. They asked her, do you have any idea why this happened? And she couldn't give an explanation. The person who had been living with him didn't know. The best she could do was speculate it's associated with his PTSD and him fighting in his dreams. But she didn't know the answer. In the PSI, she was interviewed by the PSI writer, as well as many family members and other people who just know Michael Winquist, where it was discussed that he's violent. He engages what one might call domestic violence, offering another possible explanation for what might have happened. Nobody really knows, though, because of the lack of memory, what actually caused this. I'm going to come back to that later. Michael Winquist at the time was on probation. He was on probation for felony OWI. He was prohibited by the conditions of probation from consuming, possessing alcohol, absolute sobriety. He was prohibited by the law because of the felony nature of the conviction from possessing firearms. In the PSI, he specifically talks about that shotgun in the closet. Why do I have it? It's for the purpose of protection. That is not allowable for someone who is a felon. You can't just keep it for protection, or else the prohibition would mean nothing. Everyone could just have a firearm then, and everyone knows that. It wasn't practical to think you could actually do that. As alluded to, as time passed, the injuries worsened. I don't think I can do a better way of summarizing the effect on Ms. Fickbaum that has already been explained by the victim, by her family, by the people who've observed her day in, day out over time. That wasn't conveyed by her describing herself as feeling like she's becoming a burden on the people around her, that her existence has transformed since then. She's living a different life than before the injury. She's been inflicted with devastating physical, mental, emotional, neurological injury. And they're an injury that worsens with time. It doesn't get better. I think what the court can gather from that is that this is a victim that cannot and will not ever be made whole, either through anything the court can order, through any restitution that Mr. Winquist could do, because the way she's going to experience life from now on is forever changed. This is, as far as I can tell, the worst injury, the worst impact on a victim I've ever seen in a case short of death. Because you also have those collateral consequences described too. She was really depending on the income that Michael Winquist gets to help try to save the house. She was really depending on she wants to be that mother that she was before to her child. It's apparent in everything she does and says. He wants her to be the mother she always was, and she's got these diminished capacities now. Even just the hearing loss can be a communication barrier for them, and that's devastating. So how am I applying these facts to my argument? This is where I'm going to start with what I call those accountability factors, because those are really fact-driven. Gravity of offense, protection of the public. So right off the bat, the need to punish and to not depreciate the seriousness of the offense is apparent. Probation has to be struck out right off the bat, even if not for the devastating nature of the injury and for the nature of the action and the danger of it, for the mere fact that he was already on probation when this happened. It would be perverse to do probation when someone commits an even worse offense while on probation. That's always a non-starter. I think it's apparent it can't be a jail sentence. It needs to be a prison sentence. It needs to be a long sentence. I thought it very significant in the pre-sentence investigation report that Michael Winquist himself said he should be sent to prison for double digits. He recommended over a decade of imprisonment himself. That itself conveys how well it is known that for the need of punishment in this case, for not depreciating the seriousness of the offense, we're talking about more than a decade of prison. It is absolutely necessary. Because this is a case where, as Christina Fickbaum described it, she talked about lifelong injury. I didn't mention it more as and I think she used this terminology in the PSI, that she feels like she's going to be a prisoner in her body for the rest of her life. The state's recommendation, 17 and a half years initial confinement, 10 years extended supervision. That's not going to be the rest of Mr. Winquist's life. He'll get out almost at age 50 if the court follows that recommendation. It is more than half his life that he's lived so far. It is more than the adult life he's lived so far, but it's still less than what Christina Fickbaum is going to be facing going forward, because we know the nature of her injury. It's degenerative. It's treatable, but not curable, if that makes sense for the court, if it understands that terminology. The sentence needs to be commensurate with that injury. Proportionality demands significant punishment.
Why this easy plea deal?
I'd also like to point out that the public, as I said before, these are accountability and public policy factors. The public must be generally deterred from similar conduct to this in the future. The public needs to know, to avoid the sense of outrage that would be caused by depreciation of the seriousness of the offense, that behavior like this, that has an impact like this, use of a shotgun in a house against someone in the head, in the kitchen, this needs to be met with a massive punishment. Something less than that would, by offending the morals of the community, would affect public safety, would affect feelings of community safety and public safety. That's really what these factors relate to. Protection of the public also relates to the feelings of public safety. This is where I'm going to transition into what I call the predictive factors related to the character of the offender and protection of the public. Talk about specific deterrence, rehabilitation, incapacitation. There's a reason I outlined the facts and the conflicting information about what the cause of it was, and the fact that even, Let's look at the PTSD, the sleep fighting, the domestic violence, the alcohol use. None of these is still a great explanation for why it happened. These are all negative factors that could contribute to something, but there's no explanation. What is the explicit thing that happened to cause him to get up, grab a shotgun, go to the kitchen, and shoot Christina Fickbaum in the head? I've alluded to in the past hearings, that was the main thing police were trying to figure out. We were trying to find a motive. We were trying to find sense in something that was utterly senseless. And it turns out it was a folly. And that's exactly why I think these factors do not bode well for Mr. Winquist. This was not a violent action in regards to a hot argument. This was not, what we call a hot homicide where, hey, the child in the basement heard them having a loud argument and fighting and then escalating. This wasn't that. So we can't say it was that. Could have been any of the things I described. With the PTSD, what's even the source of the PTSD? He served in the military, but he served in a non-combatant role. Could it be the shooting that happened that was alluded to by the victim advocate? Well, Mr. Winquist was simply standing outside a bar. He was shot in the buttocks by a scope rifle for really no reason at all. He did nothing to deserve it. He did nothing to call for it. Imagine the impact on you that it would have. Just stand.
An accident.
He has no idea of doing that. I'm explaining from his perspective. He's just standing in public and all of a sudden shot with a rifle. Like the impact on him in terms of PTSD on that. Could that have been the cause? Is it the alcohol? Was he in a drunken sleep, deprived of that, going through a PTS dream? Was this just an expansion of domestic violence that kept rising over time? A cold action that had a cold heat, if we're talking about American literature, with no planning and no end game. Was this related to stress from inability to pay the mortgage on time and the bank's actions to start foreclosure on it? Nobody has the answers to these questions. Not me, not the victim, not Mr. Winquist. Because of that, it puts us in a very precarious position when we're talking about the predictive factors. When we're talking about what sentence can the court do that will specifically deter this offender? What sentence can the court do that will effectuate rehabilitation of this offender? The PSI, the compass, says he comes back low risk. He shot somebody in the head and he comes back low risk. And that's not because DOC did something wrong. It's not because the risk assessment tools don't work. It's because we know the things that are predictive of future behavior, and they didn't predict this for this offender. Nobody predicted this was going to happen with this offender. And that's a problem. That's a problem because it makes it extremely difficult for the court to figure out what the sentence should be that would be the lowest amount necessary to specifically deter this offender. Can the court say, based on everything it has now, that 5 years or 10 years or 15? Can the court say, what is the thing that's going to rehabilitate him? With the alcohol, there's numerous references to it really just utterly ruining his life for his whole life, from starting young to getting busted down a rank in the military, to the OWIs, making him lose his right to bear arms, to this offense. As he was intoxicated, there's the blood results. It's a factor. We just don't know to the extent of how much. He's lost so much in his life to alcohol, and yet even while on probation for an alcohol-related offense, it's not deterring his behavior. It's not changing it. It's unworkable. When we look at the PTSD, there's multiple sources of it. He's aware of it. It's happening even in the description of Ms. Fickbaum about the sleeping, about the fighting in the sleep. What's he doing about it? It's something that's continuing. It's something that's worsening. It's something that's impacting the child that lives in the home, Ms. Fickbaum's child. He's been aware of the impact of the negative things on his life and not done anything to fix it. And especially with the alcoholism, we've seen a long history of inability to fix the problems on his own, in the community, through his own actions, even when it's impacting others negatively, especially when it's impacting himself negatively. That being said, there is something the court can specifically deter, something that I think everybody agrees happened and it shouldn't have. Two things, really. The alcohol I described, the thing that hasn't changed to no avail over a long period of time, but the possession of the firearm. I understand that most of the guns are Miss Fickbone's. They were the ones in the basement. However, he used those firearms and the firearm kept in the closet for protection that he himself said that is the purpose for why it's there. That's just disregard of law. That's just wanton disregard of law, especially allowing those things to be present when you are going through a period where you're just not sleeping, you're having psychological issues, when you are just on a long bender, when you're not making good decisions. The reason for the felon in possession of firearm laws is because people who get convicted of certain serious crimes, we've made the determination that they simply do not have the judgment necessary to safely have these weapons. That judgment's already been made by law. Michael Winquist does not have the judgment appropriate for a person to possess and use firearms. Yet he's still doing, he's demonstrating why he doesn't. It's impossible to look at this case and not think, if only he had been following the rules of probation not to drink, if only he had been following the law, none of this would have happened. I think that's really where I felt the most sense of outrage, especially from the victim when I've talked with her in our consultations. And because how could you not feel that way? I think everyone would feel that way in that situation. Because of the lack of success over time, over the military helping him with the overcoming the alcoholism, with the supervision on the OWI-4, overcoming that, with the lack of success, I think that the court needs treatment in a confined setting. That's one of the things the court has to consider. I think we've conclusively demonstrated for the things that could be rehabilitated on him, the mental health as it relates to the PTSD, the alcohol use, the sleep things, and even the domestic violence. These are all things that need to be treated in a confined setting, and that goes towards the sentence. But the real reason why I'm talking so much about there's not a good explanation for his behavior is because that is the sort of thing we look at when thinking about incapacitation. The reason I'm recommending a 17.5-year initial confinement sentence, even though Compass and the Department of Corrections says this is a low-risk offender, is because the community needs to be protected from him. Nobody saw this coming. If you asked the day before this of Christina or her child, is she going to get shot tomorrow? None of them would have even fathomed they would have been anywhere near that. Michael Winquist's behavior is not predictable. It's like trying to predict a wild animal, whether or not it's going to strike or not. And that's the real danger, and why incapacitation, to me, overrides even specific deterrence and rehabilitation in this case. Because Christina needs time to heal. She needs time to feel safe. That's going to take a while. So does her family. The community needs to be protected from this, because there are multiple things that need to be addressed, multiple things that are going to take years. A 20-year alcohol problem does not get solved overnight. PTSD does not get solved overnight. These dream walking things do not get solved overnight, and domestic violence does not get solved overnight. Addressing these four things in a confined setting will take a long time. And the mere fact that we still can't say any one of these things was the cause means the court needs to be thinking about incapacitation over specific deterrence and over rehabilitative needs. I would add that, given the nature of this offense, specific deterrence itself still does weigh in a large prison sentence. We need to specifically deter this offender from firearms and alcohol when those were two of the biggest driving factors to him shooting somebody in the head. In sum, the McCleary-Gallion factors tell us that the court should do the maximum sentence on that reckless injury, that 12.5 years initial confinement, 5 years extended supervision. It's hard to imagine a worse way to commit that offense than this. I can't think of one. I'd be surprised if the court could. On those, that grouping of felon in possession of firearms in the closet, the court should do the max of that as well. It is hard to imagine a worse version of felon in possession of firearm offense for an offender other than the offender shooting somebody while possessing firearms in their home. From a fact perspective, it merits a significant response. There is no obvious path to rehabilitation for the risk that this offender poses to society because of the myriad problems he has. He's known for a long time these issues make him dangerous, and he's ignored that despite legal and professional consequences. The firearms in the closet should be concurrent to each other because they're mostly Ms. Fickbaum's weapons. They are stored in the same place. It's Ms. Fickbaum's home. She gets to control what's in her home. And him exercising control over one or the other and just having access to the others concurrent makes the most sense there. The possession of firearm to shoot the victim in the reckless injury conviction that resulted from the same should be concurrent to each other because they were part of the same course of conduct and because they're a parcel of the same act. And quite frankly, I think they exacerbate each other. When you look at those two things together, the felon possession of firearm where you actually use the gun to shoot somebody and the fact that the reckless injury was shooting somebody in the head, they make each other worse, especially when you're not even supposed to have the gun. For those reasons, again, I'd ask for a total sentence of 17.5 in, 10 out with max on the reckless, max on the felon possession of firearm, those concurrent to each other. And then for the firearms in the closet, max on those concurrent to each other, consecutive to the other grouping. Thank you.
Thank you. Mr. Harrington.
Thank you, Judge. Before I analyze pursuant to the McCleary factors, I want to add a little more context to the circumstance. And in the course of adding to the context,
in the course of human events,
reference to Ms. Fickbaum. I want the court, I want Mr. Schmidt, Ms. Fickbaum, and all of her friends here to understand that I am not in any way blaming Ms. Fickbaum.
I'm going to crank it up a bit.
The victim of a crime, a very serious crime, and she deserves everyone's sympathy and concern. But she's involved, was involved, and remains involved in the context that led up to May 31st, 2024. Mr. Schmidt suggested that the circumstances of that day were not predictable. They were not predictable that day. But the facts, the background and the facts made this tragedy absolutely predictable. First of all, let's look at the circumstances of Mr. Winquist and Miss Fickbaum. They were engaged in a presumably romantic relationship. Miss Fickbaum's statement emphasizes that in retrospect, it wasn't romantic, it was abusive. Mr. Winquist has told me that in fact, he considered the two of them married. The initial video that I saw of an interview with Mr. Winquist and law enforcement showed him wearing a wedding ring. He wore that wedding ring for many months.
I need to stop. Is she leaving and vacating or just using the restroom?
I don't know.
I just need to ensure that I'm going to still be in victims' rights compliance.
He needs to take a break.
Okay, we need to take a break.
Sure.
All right, let's take.
She doesn't want to hear this.
Okay, this part she doesn't want to hear, but then she'll come back.
Yeah.
Okay. Mr. Harrington, you may continue.
Thank you.
Okay. She has the right to not listen as well as the right
He
to
wore
listen.
the wedding ring in jail for months. I can't tell the court when he took it off. He considered
They
that
let
they
him
were
keep your
married.
rings in jail?
They weren't, but he considered it. The court is probably aware that he received a substantial financial award because of the accidental shooting. And he, pursuant to the plea, or the PSI, he gave her $75,000 because he thought they were going to stay a couple. He needed expenses, the money to pay some expenses in the house. And they needed to make some repairs. They lived together. They shared the living expenses. They vacationed together. They enjoyed each other's company. As Mr. Schmidt noted, there was nothing on the couple days before May 31st of 24 that suggested that this event was going to happen. The discovery reflected that when in the month before May 31st of 2024, there had been flirting by email between these two. But there's one other thing that they did together that made this tragedy predictable. Right? Right. They consumed the most destructive substance in our society, alcohol. Michael's mother told the agent that her observation was that they played drinking games. Alicia Johnson, Ms. Fickbaum's son's girlfriend, opined that both Christina and Michael drank too much. They drank together. So that's the circumstance that makes this tragedy somewhat predictable. We in the court system far too often observe the tragedies that result from increased alcohol consumption. As people continue in that process, they drink more and more. They make poor choices. They engage in riskier behavior. If they continue with that risky behavior, usually that consumption leads to a tragedy, both in their lives, but oftentimes in others' lives that are just innocent bystanders. My example is the instrument of the tragedy in most instances is an automobile. This instance, the instrument was not an automobile, but it was a firearm. A Remington 870 12-gauge shotgun. So I also contend and argue that in this particular instance, the tragedy was predictable because of the circumstance, but the tragedy was also predictable when we look at the instrument that was used. During the search of the house after the crime, law enforcement discovered a number of firearms. They discovered the shotgun, which was out in the bush, and the child had thrown it there.
In the bush.
They discovered a loaded handgun in the kitchen drawer. Loaded in that the magazine was in the butt, in the drawer. And that was Christina's handgun.
There's different ways to say that.
They discovered in the
Magazine was in the
basement closet behind a dresser a loaded Remington 30-06 rifle. They discovered a loaded .22 Marlin rifle and a loaded 22 caliber Mossberg rifle, all kept in the basement. So these folks were consuming alcohol and had loaded firearms in and about the house. The tragedy was predictable. The date was not. But the date was May 31st, 2024. All those facts came to head, resulting in this tragedy. Michael Winquist and Christina Pickles had consumed alcohol beverage during the afternoon, and I'm making these factual statements on the basis of the discovery. They had consumed considerable amounts of alcohol. The discovery reflected that both Michael's blood alcohol, this was 0.215, Christina's was, and I'm not sure where I got this number. Christina's, per my notes, was 0.297. I don't remember where I found that, it was in my notes. I rather suspect that I got that number from some electronic discovery that I received. They consumed the alcohol. They visited a neighbor. Christina was driving the motor vehicle. We don't know precisely the sequence of what happened because, according to the discovery, neither Michael nor Christina could remember a sequence of events. We do know that Michael had napped, had a bad dream, woke up, grabbed the shotgun, fired it, striking Christina in the head. He is the victim of this horrendous tragedy, no doubt. As noted, there are three factors the court must consider in sentencing a defendant: gravity of the offense, the character and rehabilitative needs of the defendant, and the need to protect the public. The gravity of an offense or offenses is generally a comparison of what the crimes are, what's the maximum penalty, and other penalties that the legislature has determined are appropriate for a certain course of conduct, the maximum penalty. And then the other thing we look at is what happened. There isn't any question that these are serious offenses. The maximum penalty for count 1, second-degree reckless injury, use of a firearm as a penalty enhancer, 12.5 years confinement with 5 years of extended supervision. Those are the maximum penalties. With respect to felony and possession of a firearm, the maximum penalties there are 10 years with 5 years of confinement and 5 years of extended supervision. Are not as serious penalty when you look at the public policy as determined by the legislature, but serious in any event. And they should, the count 2, second-degree reckless, should be more serious because it is based upon reckless injury. Whereas counts 3, 2, 3, 6, 7, and 8, possession of firearm by a felon, are really status offenses. Although one can certainly argue that 2 is not just a status offense. And I concur with Mr. Smith that it should be held together or bound together with the sentence as to count 1. Counts 3, 6, 7, and 8 are status offenses because people convicted of felonies, whether it be felony non-support, OWI felony, or any sort of a felony, shouldn't possess the firearm. The legislature has made that policy determination, and it's appropriate. Suffice it to say, this is a serious offense because of what happened to Christina Pickles. struck on the head, the shoulder, with after the shotgun was discharged. The impact on her life is profound and permanent. These are serious offenses. There is no argument about that. Character and rehabilitative needs of the defendant. Michael is now 31 years of age. He's a high school graduate. He honorably has been discharged from the United States Marine Corps. Some of the people interviewed by the Department of Corrections agent, one person in particular, and I don't remember who it was, and it doesn't matter, said that merely because he's a veteran, he isn't entitled to any break. Agree with that? Michael agrees with that. Michael agrees with that. Michael was a United States Marine, is a United States Marine. And Marines accept responsibility and adapt their life to accept that responsibility and serve their public. Michael received his first OWI when he was in the Marine Corps, and the PSI reflects that he accepted that responsibility. He lost pay, he lost rank, he worked hard, regained the rank, and eventually was discharged honorably from the United States Marine Corps. He was injured while on active duty, receives a 90% disability benefit from the Veterans Administration. He had been employed until he was the victim of the accidental shooting in 2021. He contributed to society. He contributed to the household. He was a substantial contributor towards the expenses of the household. And as noted, Ms. Pickles provided care for him in his rehabilitation. During the healing from the gunshot wound he received,
so he got shot
he had
accidentally
too much
first
time on his hands
and
and
received
money.
a settlement for that.
And if we look at the course of his life, he began consuming alcohol at 12. It became problematic at 15. His alcohol consumption probably declined during his Marine Corps service. But after he was shot, he had too much time and the alcohol spiraled out of control. He was convicted of OWI 4, and that did change his life because it doesn't appear that he was particularly driving on May 31st of 2024. Michael didn't have a father figure growing up. His relationship with his own father was strained. He only saw him sporadically. His mom was a single parent and was working, and Michael and his brother really had to take care of themselves, discipline themselves, and had brotherly disputes. People learn their parenting skills from the parents that they have. There was much discussion in the PSI about Michael's disciplining of children. Michael's using a stopwatch to make the kids eat in a specified time. Judge, having been a United States Marine myself 50 years ago, that's what drill instructors did.
Judge didn't resonate with that one.
Then it was. Is it an appropriate parenting strategy? No. But that's where we're at. and Michael. Mr. Schmidt mentioned the PTSD-like trauma or diagnosis. The evaluator for the NGI evaluation diagnosed him with a trauma and stressor-related disorder. It may qualify as a mental disease or defect, but not sufficient not to an extent to support the NGI defense.
I like this court because it has a quilt on the wall.
The
What other court
evaluator
has a
opined
quilt?
that Michael Winquist may be appropriate candidate for mental health and or substance abuse treatment. You know, that was an interesting opinion from the evaluator, but the court, Mr. Schmidt and I have all worked in this business for many years. And we didn't need an evaluation that tells us that when we look at all the facts here. Michael's not perfect. Made mistakes.
Captain Obvious is going to continue his closing here.
He loved Christina Pickles. It was love. Michael does want the court to know that not everything said about him in the PSI is an accurate characterization. He is very much remorseful. The agent concluded that he had no remorse because sometimes Michael hesitated when he was answering questions. Victims, DOC agents, judges, prosecutors. Judges and prosecutors know this more than others. Clients are instructed by their lawyers to be very careful with what they say in jail to agents and others. When we started the PSI process, I told Michael to be truthful, to not blurt out answers to the agent's questions, and to take his time. Did that. And Ms. Lineweber drew those conclusions, but that's the explanation for his hesitancy and that sort of thing. Michael's going to read a statement. Ms. Fickbaum and her advocate outlined that Michael has never apologized. And again, that's at my recommendation. Any statement a defendant makes while has jeopardy can be used against him either at trial or at sentencing.
So now that he no longer is at jeopardy,
And does not make statements that can create more legal issues when you're facing these sort of.
So he won't apologize now either because his sentencing hasn't been decided until after his statement.
I mentioned that the characterization of Michael's relationship isn't entirely accurate. I mentioned that Michael wore the wedding ring. He has her name tattooed to his chest. He says that his name, at least one time, was tattooed to part of Christina's body. He gave her the $75,000 to pay her bills. He commingled his veteran benefit and paid a large share of the living expenses. He wasn't always employed, and he helped her, and she helped him.
Just be done. Sit down.
Specifically, he denies the
Found his second
characterization
wind.
from his ex-wife. He tells me that that was not, at the end, a pleasant experience for him or her. She, according to Michael, holds a great deal of acrimony to him. As the court can see from the PSI, the children went back and forth between Wisconsin and Oklahoma, sometimes by legal order and sometimes by come and get these kids, I'm tired of them. And that's her saying that to him and him saying that to her. And then when most at the time of this incident, the children were living with her. Finally, Michael admits these crimes, stands ready to accept the court's punishment. Protection of the public. That is that third McCleary factor. And we all know what the case law says. It says that if appropriate, community supervision ought to be the first disposition. Does Michael Winquist need to be incarcerated for 30 to 35 years, as many think, to protect the public? No, he doesn't. Is his underlying personality and substance abuse dependency issues so severe as to preclude treatment within the community? No, it's not. Would not imposing a period of confinement unduly depreciate the gravity of this offense? And there isn't any question. The answer to that question is yes. The profound impact on Ms. Fickbaum, the use of a firearm, possession of a firearm as a felon, all those facts suggest that there needs to be confinement here. It's appropriate now that I comment on a couple things that Mr. Schmidt said. And Mr.
You already said finally.
Knew he had this post-traumatic stress type disorder. He knew he was an alcohol, consuming alcohol to excess, that he was an alcoholic, that he had substance abuse issues. He knew that he had bad dreams. He knew that the firearm was there. But we see people like that all the time. People that have substance abuse issues, they can't solve it in a day. It's not a logical question that they have in their mind. I'm a drunk. I'm going to go get cured, and it happens. That isn't what we see. General deterrence, in my opinion, doesn't work. If there's a severe sentence here, isn't going to change the fact that somebody else that drinks too much and that keeps loaded firearms in and about their house isn't going to have the same tragic circumstance. That isn't how general deterrence works. Specific deterrence, I agree with Mr. Smith. Specific deterrence deters this particular person from this particular behavior. So there does need to be a period of confinement to not depreciate the gravity of what happened here. Dramatic impact on the victim, continued consumption of alcohol, and the possession of a firearm. With that, how long should Mr. Winquist be confined? Department of Corrections, just to count one. Department of Corrections, with respect to all counts, did not recommend a maximum penalty as to any of them. That sort of surprised me a bit. But the Department of Corrections, the agents, the supervisors are familiar with all all the law that we have, everything we've talked about, all the dynamics of substance abuse, mental health issues, and the range of penalties for these similar type crimes. As to count one, the Department of Corrections has recommended as a maximum in their range, 8.5 years, 6.5 years of confinement, 2 years of extended supervision. As to count two, the department recommended 3 years imprisonment, 2 years confinement, 1 year ES consecutive to count one. Then counts 3, 6, 7, and 8. The department continued with that 3 years as to each, 2 years confinement, 1 year ES, but all consecutive to each other. I agree with the Department of Corrections analysis, with the exception is counts 3, 6, 7, and 8 should be concurrent with each other, but consecutive to counts 1 and 2. That's the analysis of the Department of Revenue, Department of Corrections.
The IRS
Their
didn't weigh in on this
status
one.
offenses, the firearms for counts 3, 6, 7, and 8 weren't in the bedroom. They were downstairs, in a closet, behind a dresser, loaded. They were loaded. At no time during the investigation of this were those firearms tested to see if Michael actually touched them. There weren't any fingerprint analysis.
They're not allowed to be in the home where
There
you
was no
stay.
DNA analysis on the firearms. If you look at the photographs of the firearms, there was rust all over those things. They hadn't been cleaned. They hadn't been properly preserved. So there should have been some effort to investigate and determine if Michael actually touched them after his OWI 4th conviction. That's why I emphasize that these are status offenses. They were in the house. They were available if he wrestled around for them. He's a convicted felon. They shouldn't have been there, but they were. And that's the basis for those convictions as to counts 3, 6, 7, and 8. I urge the court to adopt the Department of Corrections recommendations, with the exception that counts 3, 6, 7, and 8 be consecutive to consecutive counts 1 and 2, but concurrent with each other. Judge, I started this conversation, this argument, with noting the tragedy. And it truly is a tragedy. Could it have been avoided? Yes, but it would have taken Michael to recognize his substance abuse. Did not. And we're here. And that's what this is for.
Sit down.
A final note, Michael paid the $10,000 initial payment on restitution a couple months ago. He tells me he sent another check for $2,582.23 to the court just within the last couple of days.
It
The
was
restitution
confirmed.
request has been paid.
It has been confirmed that that has been paid.
He did have money, came to him from
So
that
what is
settlement.
the total initial and total extended supervision you are requesting?
10 years, 4 years ES. 10 years initial
10 years in,
confinement,
4 years.
4 years ES.
Under electronic supervision.
Right.
So we've got some space between the two recommendations.
Actually, 10 and a half years, Judge. I'm sorry.
Okay.
6.5 on count 1, initial confinement. 2 on count 2, initial confinement. 2 on counts 3, 6, 7, and 8. Count 2 consecutive to count 1. Counts 3, 6, 7, and 8 consecutive as to counts 1 and 2, but concurrent with each other. We believe that satisfies the needs and is appropriate. I have calculated his credit days through today at 565 days, including today. Thank you, Judge.
So 564 because you don't count today.
560.
She's like, I did the math. You don't count today. It doesn't count. Or make you serve every possible day.
Mr. Winquist, I'm now going to turn to you and give you an opportunity. Actually, I'm going to wait to see if the victim would like to come back in. All right, the victim is now back in the courtroom. Mr. Winquist, I'm now going to give you an opportunity to tell me anything that you would like me to know. This is where you can state anything that you've heard that's been inaccurate, or you can go into more depth about things that have been argued or stated or that are in the facts in this case. This is where you have the ability to show any remorse or anything of that nature. You do not have to give a statement today, but it is your only opportunity. If you are going to read something, please read it slowly, enunciate your words, and please speak into the microphone. Okay. You may begin.
Thank you. I would like to make an apology.
Harrington, can you please move the microphone closer to him?
I'd like to make an apology to Christina. I'm beyond sorry for what happened that night. It's so unfair what happened to you, and I will regret that moment for the rest of my life. I think about it every day and hate myself. I would give anything to change the outcome. I'm deeply sorry and hope the best for you.
To change the outcome.
I would also like to apologize to Donovan. You should have never had to deal with that trauma, that situation. Very sorry. And also to all your family and friends that have had to take care of you because of my actions. I know none of this changes anything for you, and I will mourn this for the rest of my life. Sorry.
That was it. Okay, so it was...
Is that all?
Yes, Your Honor.
Let me turn this to the court reporter so she can jump to me.
Yes.
Court reporter gets a copy of the napkin he wrote that on.
Would you like that filed as a document or just with the court reporter for record of the record?
You can file it as a document, Judge. Then,
okay.
Then it'll be there.
Then she has a copy, she'll get a copy, and then the court will have a copy.
Hang on.
Okay, thank you. The court has reviewed the PSI multiple times. I've highlighted, I've taken notes. I've read this so that I could have a better understanding of you, Mr. Winquist, a better understanding of the victim and victims here, as well as a better understanding of what happened or what people believe happened that day. Your attorney has stated, and the the state has as well, the factors, the things that the court has to focus on when it comes to sentencing. Number one is the nature and the gravity of the offense. How serious is the case? Is this matter? I have to look at your character, your prior criminal record, any rehabilitative needs or other things with you. I also have to look at the need to protect the public. And here it's twofold. It's the victims as the public, as well as the general public. Because I believe everybody can state that this is true, that alcohol and firearms is very serious And it's a threat not only to the people in the near vicinity, but it could also pose a threat to people in the general public. That's why we have separate, firing a firearm while intoxicated and other crimes related. It's serious. The court also has to look at the effect on the victims. Again, your rehabilitative needs, any undesirable behavior patterns from you, your culpability, your age, your education, the history. And as Mr. Schmidt pointed on, as well as your attorney did, deterrence. There's two types of deterrence: general deterrence, to generally deter others from thinking about doing something similar. And there's specific deterrence, deterring you specifically from committing this crime and other crimes. I have heard and considered the arguments from both attorneys. I have heard your statement. I have read again the information contained in this pre-sentence investigation report. I have heard multiple victim impact statements. And it's a lot for the court to digest. You have admitted here to these very serious crimes through a plea agreement with the state. Count 1 was amended down from attempted first-degree intentional homicide, domestic abuse. It was amended to a second-degree reckless causing injury with a domestic abuse enhancer, as well as use of a dangerous weapon enhancer or modifier. You pled guilty to that offense, and you have pled guilty to 5 other very serious offenses of possession of a firearm by a convicted felon. When the court first tallied what prison time was originally hanging over your head, I arrived at approximately 130 years if the court did a maximum possible penalty.
Whoa.
Because if you were to have been convicted of the original charge of attempted first-degree intentional homicide, domestic abuse, upon conviction, you may be sentenced to a term of imprisonment not to exceed 60 years. And then that was amended down to the second-degree reckless injury with the domestic abuse enhancer and the dangerous use of a dangerous weapon modifier, where the maximum possible penalty could be the initial 12.5 for the second-degree reckless, with the ability to increase an additional 5 years of initial confinement because of the use of the dangerous weapon and that modifier. All in all, due to the agreement that you've reached with the state, the plea agreement, you essentially avoided a life sentence if you were convicted on all of the original charges. Ms. Fickbaum does not have the same ability to avoid that life sentence. She will continue to live with this day in and day out, not only the emotional turmoil and effects, but the physical effects that she has and will continue to suffer from, which then leads to financial effects and other mental health effects and other things that will seep and continue to seep into her life for her life. And as she stated, you may not have killed her, but her life left her that day. And another thing that she has stated in the PSI is that now she is a shell of her life. She has no home, no car, no money. She cannot live by herself because she cannot manage bills. She forgets things. She falls. She has fear and anxiety. It is a life sentence for her. The primary dispute here today is not whether or not the court sentences you to prison. Both sides agree that this is a prison sentence. It would unduly depreciate the seriousness of the incident and the offense that has occurred. But here the court has to look at all of those factors and all of those things to determine what is an appropriate sentence in this case. Because the court must order confinement at the minimum amount, which is consistent to protect the public based upon the gravity of the offense and your rehabilitative needs. There's not a formula that does that. I can't type it into an equation and have it shoot out an idea of what is an appropriate sentence. And I know the Department of Corrections has something with their compass, some ability to do that. They don't just pull their numbers out of the air. And I know Mr. Schmidt made a comment as it related to your compass. I don't rely heavily upon the compass scores, and I'm not sure how thoroughly your attorney went over that with you of what that means or what that is, but I don't rely heavily on the compass rating or the score. I don't necessarily think it's evidence-based. I don't think that it gives a real idea of the defendant and their ability or lack of ability to stay crime-free. Here, your compass score showed a low risk, that you would be a low risk to commit more crime and violent crime. And that's coming from an incident where you had a gun, a shotgun, and you shot your girlfriend in the head.
There's the summation.
So that's where the compass really doesn't come into play, or I can't rely upon it heavily, especially because the compass in other serious crimes, such as child sexual assaults or offenders or child pornography cases, those individuals also generally show a low risk. So I can't gauge based upon that. What I have to gauge upon and what I have to look closely on is your history, whether this is an aggravated incident, an offense, if there's aggravating factors. I have to look at your ability to rehabilitate, your ability to understand the seriousness of your actions, and not just your action in this incident. We all know that this is extremely serious. There are allegations of domestic abuse between you and the victim and you and your ex-wife. I don't have anything that confirms that. I don't have that you have a criminal history as it relates to that. I don't even have a criminal history of violence with you. It's all alcohol related for the most part, except for perhaps your 2018 conviction for obstructing an officer. But if I look at the underlying facts, I'm going to guess it probably had alcohol relation. And you're nodding your head up and down, so that tells me it did. You have an alcohol problem. You are an alcoholic. You cannot, you should not in any way, shape, or form ever touch a drop of alcohol. And I have to go to a statement made by your counsel as it relates to your operating while intoxicated fourth offense, fourth conviction, which is a felony. It was stated that that OWI fourth conviction changed your life. I don't see it changed your life at all. Not one bit. You continued to drink alcohol while you were on probation. You continued to engage in other activity that you were prohibited from while on probation. The only thing your OWI 4 conviction changed your life in was it took away your right, your privilege, actually, your privilege to be able to operate a motor vehicle and have a driver's license, because it took it away for life. But I'm going to tell you, I don't believe for 1 minute that you didn't drive illegally after your OWI 4th conviction. Perhaps you didn't on this day, as your attorney said, because he said this changed your life because you were no longer able to drive. And it appears he wasn't driving the day of the incident. That's the only thing that it perhaps changed your life. Maybe you didn't drive that day, or we have no facts that suggest that you drove that day. But the fact that you couldn't abide by your probation conditions, the fact that you continued to drink alcohol after your OWI 4th conviction while you were on probation, the fact that you continued to possess firearms when you are a convicted felon, leads me to believe that you wouldn't follow the lifetime restriction of no driving or having a driver's license either. So I don't think your OWI 4 conviction changed your life. If it had, perhaps we wouldn't even be here today.
Spitting the truth here, Judge.
I do know that that day did change the victim's life. It changed her son's life. It changed her entire family's life. She now feels like she is a burden. She's not the same person she was previously. And she feels she never will be. And I know that it was brought up in the PSI and was brought up in arguments here today that, and from the victim herself, that you were shot with a rifle during an incident. I remember that day, not that day, but I remember that incident very clearly because that impacted your OWI 3rd conviction in front of me. That incident occurred when you were at a bar. You were standing up outside or something like that. The individual was cleaning his rifle in a house across the street. There was a cord on the floor. He was walking with the rifle. Somehow the safety wasn't on and it was loaded. Those are no-nos. But he tripped and fell. The gun shot through his glass sliding door, shattered the door, went across the street, went to the area on the bar's property where you were, and struck you in the buttocks. Accident.
Sorry. Sorry.
It was an accident. This incident was on purpose.
Allie B from Tennessee.
It wasn't an accident that you picked up a shotgun, you pointed it at your girlfriend at the time, you pulled the trigger, and you shot her in the head.
You thought she was dead as well.
That wasn't an accident. No matter how many people don't remember what happened or the incidents that occurred that day, or what was going through your mind, that was not an accident. Yours was an accident. Your PTSD, if you have it, and that's been said that it could be from that, or could be from this or that or the other, any trauma that you have suffered from your shot in the buttocks, completely, 100%, totally different than the trauma that the victim here suffers from. Because she had somebody who said, I love you. She had somebody who said, from the words of your counsel, you thought you were married. You wore a wedding ring and you pledged yourself to her life, to her betterment, to make her a better person and to have this life. And you picked up that weapon that you had no legal right to possess, and you shot her in the head. It was not a heat of the moment type of incident. We don't have anything that from the juvenile who was there, who heard fighting all day, who heard a huge fight, and then all of a sudden a shot. He was downstairs in the basement playing a video game. He didn't hear that.
I'll have to share my story about shot in the butt. I've got one.
You have had alcohol issues since you were 12. I know that it's been stated that that's when you started using alcohol, and it didn't get bad until you were 15, and you didn't have a problem until 15. But I'm going to tell you, starting drinking alcohol at the age of 12 is bad.
A problem.
It shows an issue. And again, you nodded your head up and down. It is. That was the start of your downfall. And whether or not your consumption of alcohol decreased while in the Marines, which again is kind of hard to believe because of the stories I've heard of people in service. Even if it did,
in the Marines, it must have been a lot.
Once you returned and you were honorably discharged from the Marines and you came back, that's when it started again. Not from the date of when you got shot in the buttocks. Because again, I remember that because as I took your OWI 3rd conviction and I was being lenient to you in that conviction and was going to allow you to not have to sit in the jail for the 48 consecutive hours by law you're required to do, to serve that on an electronic monitor because of your injury. I took your conviction, you went up to jail to be processed, and you blew a 0.2 something. You were beyond legally drunk when I took your OWI 3rd conviction. So I had to redo that conviction to ensure that you remained sober. And no, I did not allow you to get out on monitor. That's where I found an error in the PSI. You had to sit in jail. I did not allow you to be released on monitor because that was serious as well. So your alcohol issue is what has gotten you here in part because both sides have argued and stated that you ignored your issues. You ignored the things that were going on in your life and with you. You ignored your alcohol issue. You ignored the PTSD that you felt. You ignored the violent nightmares that caused you to have outbursts. You ignored all of these things. And it put others at risk. And again, I want to stress, it didn't only put the victim and her family and son at risk. It essentially could have serious harm could have occurred to the public in general because of this. Alcohol and guns do not mix. And the fact that you were convicted of an OWI 4th offense of felony, you were told you were still on probation, you were told that you could not use or possess any firearms. That meant it's not all on Miss Fickbaum's shoulders because it was her house. You live there too. And as you said, you felt she was your wife. It's not all on her shoulders. You as the felon, you on probation, you are the one who knew that any weapons in that home needed to be under lock and key, or they could not be in that home. And you were not able to have access to that key. It's not all on Miss Fickbaum's shoulders because that was her home. You are the one who knew exactly that you could not use or possess firearms. Yet you did. And the argument or the statement made was you had the shotgun to use for self-defense. That is not an excuse. That is not a reason to have an exception for a prohibition to firearms. There would be if your life at that moment, you needed that weapon for self-protection because it was imminent and you were in a life-threatening situation. You were not. And as applied to you with an OWI 4th conviction, still on probation, extreme alcohol misuse and alcohol disorder, you had no judgment or no judgment to even be around firearms. Alcohol and firearms are dangerous and can be very violent. So as applied to you, that prohibition is necessary. And then you add all in your personal issues, the violence, the aggressiveness, the PTSD, those nightmares. On top of that, especially as applied to you, the prohibition is necessary.
All right, Judge, give us the lowdown.
I do have to look at your rehabilitative needs and to see if you have the ability to rehabilitate, if you want to rehabilitate, if you want to change your life. Because this, as it's been stated or argued, that this has impacted your life as well. It's kind of like a shot again to the victim that it's impacted your life. Your freedom may be restricted. You may be incarcerated for a significant period of time, but one day you will be released, even if it is on extended supervision, and you won't be suffering from the lifetime effects that the victim is. Not to mention her son. The trauma of having to hear the thud, knowing the thud when he came up was his mother, knowing she was shot in the head, not knowing if she was going to live, having the fear that you could have, in whatever state you were in that day, knowing, not knowing, shot him and killed him. How you've devastated his life and his relationship with his mother, She's not able to do activities or do things as much as she was before. He now feels like he has to protect her. He now feels like he has to be the one to care for her. He's a child. He is a child who does not deserve to have to worry about these things. And now he does for the rest of his life. I want to make sure that I have covered everything that I have highlighted. As I'm looking, I do want to point out that it's a miracle. And thankfully to all that believe in higher powers, it is a miracle that Ms. Fickbaum is alive. But what she suffers from daily is worse than death. I'm not going to even expand upon the statements made about the other domestic violence with your ex-wife or the things that I think are abuse, emotional abuse, and other things with your children, and the fact that you had them eat under a timer, because I don't have any real concrete information that either of that has occurred. Because you do state, and you have stated to the DOC agent, that you were never physically abusive to Ms. Fickbaum. You were never abusive. You were not a violent or abusive person. The PSI says that there is a lack of remorse, and I know that Ms. Fickbaum has stated that that is something that she has been missing as well, seeing a lack of remorse. Your attorney has stated that he has directed you not to speak about that. You did provide that here today in a statement saying that you are sorry for those actions and what happened. That shows some remorse. I'm not sure how much, but that shows some remorse. Now, in factoring everything together and looking at the totality of the circumstances here, and especially looking at the gravity of the offense and not wanting to unduly depreciate that gravity, and to find a term of incarceration to meet the court's objectives, the court believes that a sentence that would not unduly depreciate the gravity of the offense to fit the crime and the crimes that have occurred.
Why does he insist on coughing right into the microphone?
And especially because the court views the fact that you were on probation, you had a no drink of alcohol prohibition, you had a no firearms prohibition, and that one's for life. The court finds that that is an aggravation of this incident, and it aggravates what happened that day.
Here comes the sentence.
And although Ms. Fickbaum may have engaged in alcohol consumption that day, and She may have been extremely intoxicated as well. She in no way played a factor in you taking that weapon, you taking that gun and shooting her in the head. None of that, none of it is her fault. None of it. With regards to count 1, the second-degree reckless injury
Get your
with the
calculators out.
domestic abuse enhancer and the modifier of use of a dangerous weapon, the court is going to sentence you to 17 and a half years of initial confinement. That would be the 12 and a half years for the underlying second-degree reckless injury, plus the max for the use of a dangerous weapon modifier of 5 years. The court finds this to be so egregious, so serious, that the maximum possible penalty is necessary not only to protect Ms. Fickbaum, but to protect the public in general, because I have not seen that you have a desire to follow the rules and to follow the law in any way, shape, or form.
Judge, I'm interrupting. I do that at risk. You said 17 and a half years confinement. I think the maximum is 17 and a half years imprisonment, 12 and a half confinement, 5 and
12 and a half okay, I read that on Mr. Schmidt's argument. So 12 and a half years, well, Mr. Schmidt, because it says the maximum, not more than 12 and a half years. Oh, 7 and a half is the maximum. Sorry. I apologize for that. So with count 1, the court is going to sentence you for the underlying second-degree reckless injury, 7 and a half years of initial confinement. And then the maximum for the use of the dangerous weapon, totaling 12 and a half years
So that
of
shaves
initial
5 off.
confinement
12 and a half
with 5
in
years
prison.
of extended supervision.
So a total of 17 and a half years, but 5 of it is released on parole or on electronic monitoring.
As it relates to count 2, possession of a firearm, convicted felon, the court also finds this egregious. The fact that he knew he was a convicted felon, as applied to him, it was very serious. He was simply just on probation not too long before that. The court finds that a maximum of 5 years of initial confinement and 5 years of extended supervision is necessary. Counts 1 and 2 are consecutive to each other.
Who's doing the math here? Consecutive. That means one after another.
As to count 3, possession of a firearm by a convicted felon. The court finds that that is still serious and egregious. No matter where the firearms were placed, he knew of the prohibition. He knew that that was for life. He was still on probation. He was on a no alcoholic drink prohibition. He was extremely intoxicated. The court is going to sentence him to 3 years of initial confinement with 3 years of extended supervision. That is consecutive to counts 1 and 2.
So 20 and a half now of initial confinement. $13 on the back end. It's up to 33 and a half.
As to count 6, possession of a firearm by a convicted felon, the court finds the same. 3 years of initial confinement with 3 years of extended supervision. That is going to be consecutive to counts 1 and 2.
But concurrent with 3?
And
thank you for not coughing into the microphone, sir. Jamie Latorno.
And concurrent with.
Got to visit sometime.
Count 3.
So it is concurrent with 3, so that doesn't add to the total.
Or count 7, possession of a firearm by a convicted felon. The court also finds the same things as to counts 3 and 6. 3 years of initial confinement, 3 years of extended supervision. That is consecutive to counts 3 and 6, consecutive to counts 1 and 2.
Okay, so this is higher math.
Did you say consecutive or concurrent? 7 is concurrent with 6 or consecutive?
Consecutive. It's consecutive to all counts.
So that does add to the total.
Count 8, possession of a firearm by a convicted felon. Same basis. 3 years of initial confinement, 3 years of extended supervision. 8 is concurrent with count 7, but consecutive to counts 3 and 6, and consecutive to counts 1 and 2.
Man, this is next level math. I would need a flow chart.
In my calculation, it's 26.5 years of initial confinement.
Barb, you nailed it. 26.5. You got it the first time.
And I believe 16 years of extended supervision.
Wow.
The court finds this to be so egregious, so serious,
total,
and so preventable. Had Mr. Winquist recognized his problems and did something about it, he did not. He failed to do anything, and he had sign after sign after sign, and he failed to even recognize or address them. And he continued to violate the law. He continued while on probation to violate the law and violate his conditions of probation multiple ways. On extended supervision, when he is not eligible for early release programming, either the challenge incarceration program or the substance abuse program. Until the last 3 years of his sentence, if any. On extended supervision, absolutely no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription, gainful or some type of employment to occupy his time and his mind. It does not have to be full-time. It can work with his disabilities. Absolutely no contact with Christina Fickbaum or any of her family members, any residents, any employment that she may have or her family members may have.
You need to specify, because we had family members reaching out. Remember the haircut incident?
The court is also going to order that he has an AODA assessment and follow through treatment. He engages in some type of criminal thinking, such as thinking for a change or breaking barriers.
Well-known programs to help you change the way you think.
The court is ordering $12,582.23 in restitution.
That doesn't cover the medical bills.
The court is going to order $518 in court costs and fees per count, except for count 1 has an additional $100 due to the domestic abuse surcharge. These are felonies. Absolutely no use or possession of firearms for life. No voting in any election until your civil rights are restored. Court is ordering his DNA. This is not something he can have expunged due to the seriousness of the crime. Failing to pay his fines and fees, a civil judgment will be entered. If he is released on extended supervision and has not paid his fines and fees, a warrant will be issued. He can sit up to an additional 6 months in jail. Restitution is paid, so the court is going to order at minimum a monthly payment.
Wow. She's getting
Of
him.
$150 per month until paid off in full. The court ordered court costs, surcharges, and fines are to be collected as a percentage as determined by the Department of Corrections to be reasonable while he is in a state prison, and as a condition of extended supervision, he is ordered to pay those upon release. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe I've covered everything, Mr. Schmidt.
Just to clarify, I think I wrote down wrong about 3, 6, 7, and 8. The court ordered 3 and 3 out on all of them. They're all consecutive to counts 1 and 2. 3 of them are consecutive to each other. 1 of them is concurrent to that group, totaling 26.5 and 19 out.
19 out?
No.
You could have added the ES correctly. I didn't write down the ES. I was trying to do it by my head.
Okay.
So,
Did I state the rest correctly?
correct.
Okay.
Anything else that is missing, Mr. Schmidt?
That wasn't missing. I think I just heard wrong.
Mr. Harrington?
No.
All right, then we are adjourned.
We are adjourned. Well, a very abrupt stop considering how long we spent there. But I wanted to see that one through for the victim. I do like this judge. She's very thorough. I like how she treats people who are making efforts to make changes in their life. Even when they make mistakes, if they have shown consistent efforts to improve, say for instance her sobriety courts, she understands that so well. She understands that whole process so well, and does a great job there. She can be a little bit of a she has an edge to her. She can be a little hard on people. I have to say thank you so much. Thank you so much. Look at this. I missed it. Alibi in Tennessee. It just barely went away. Thanks for the massive super sticker. I went to click on it and it just cleared off the screen. I apologize. And now for some reason I can't see it. I also had to call out Deidre Tyler. Welcome to the gallery. Thank you very much. You're one of us now. You can never leave. Wallflower OG. Good morning. 34 months. Keeping the cattle bedded, warm and fed. Moo. I mooed before as well. Little Bay member for 14 months as well. Thank you, RA mods and mods. Please like. Thanks for peace. Thank you all. Peace. Thank you. All right. It is lunchtime. I said we might have another court. That one did not pan out. Unfortunately, we're trying to keep an eye, as I showed you, on all the different courts that are happening round about the area. But 4 box. Let's see. Judge Boyd is done. Judge Chisholm is off. We've got one more judge that's active right now.
Yeah. And so let me, I'm just going to print it. It'll be easier for me to print it. Oh, thanks. So In
Come on in,
24
Troy.
DCCR 1791, I've got
Adds
a
to the
motion to
pickle
revoke
fun.
your unadjudicated probation. Shows that you were placed on sorry. Would the state like to make an oral motion to amend the motion to adjudicate?
Yes, Judge.
Okay. To read?
To read that it is a state jail felony.
Okay, no objection to that. Okay, so again, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 24th, 2024 for the state jail felony offense of theft of a firearm. And that was a 5-year deferred probation. Is that correct? And it alleges in count 1 that you violated your probation by committing the offense of unlawful carrying a weapon May 12th of 2025 in Jefferson County, Texas. Is that true or not true? Count 2 alleges that you committed the offense of unlawful carrying a weapon May 25th of 2025 in Jefferson County. Is that true or not true? Count 3 alleges that you committed the offense of minor in possession of alcohol May 25th of 2025. Is that true or not true?
True.
Count 5 alleges that you committed the offense of resisting arrest or transport May 27th of 2025. And is that true or not true? And then count 6 alleges that you failed to report as directed February 10th and May 15th of 2025. And is that true or not true?
Yeah, you're getting revoked.
Did you enter your pleas of true to counts 1, 2, 3, 5, and 6 freely and voluntarily? And because those counts are actually true. I have some documents on the tablet like we had before that you've done today with Ms. Holmes. Did you go over those with her before you signed them? You fully understand them. And you understand if I follow this agreement, you'll be waiving any right to appeal. State tenders number 1. No objection.
It's admitted. Any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 3, 5, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of a firearm. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification
Okay, so
that
hang on.
shows this was an agreement that I followed, so you waived your right to appeal. I also handed you another
We're going to
copy
bail.
of that
Hold on.
admonishment regarding.
Something's happening in Judge Boyd's court that I
You're
just
welcome.
wanted to
Who's
catch.
next? I'm working on 2 pleas too. Okay.
Great lady lawyers, great lady judges we have today. Many of them. They're fantastic. I'm not sure what happened here, but I just saw her laughing pretty hard with the attorney.
I'm ready. Emmanuel Galindo.
Present, Judge.
Where's your client? Oh, there he is.
Hello, Mr. Galindo.
Morning, Your Honor.
Morning.
Is his name Duolingo? Named after the app? Or maybe he created it. I don't know.
So on this case, it's from 2016.
Whoa.
So am I the judge who heard his jury trial or no?
No, Judge. It was Judge Hilbig at the time was the one who presided on the case.
So have there been conditions given to him or no?
Judge, I'm looking at a court summary. I don't know if the court has it. I can.
No, I do.
Okay.
Thank you.
I do believe that conditions were set at one point. At least I saw the conditions specifically to the other counts, but I don't know about as it relates to this specific count.
All right. And the location where he wants to reside is with his daughter?
The issue where he.
Have you taken parenting
Backtrack
classes?
a little bit, Judge. So the issue, the address where he's residing or would reside is where his sister lives.
Mhm.
His sister, Niece. I'm sorry, his niece, his niece. That address has been approved by parole. His niece does have my client's daughter residing there as well. And so the issue is that the address has been approved by parole. My client has been compliant with the requirement that he wear a monitor at all times. The issue is that probation, because of the SONU conditions, is not allowing him to reside in that address. And so if he moved out of that address somewhere else that's not approved by parole, then he's maybe violating parole conditions. And that's,
All right, so we're in a little bit of a limbo. State, I'm assuming you're not approving.
Correct, yes, we don't agree to allow living with any minors.
All right, so what I can tell you is I'm not even allowed to even consider this until the parties who are in the household are approved as chaperones by the sex offender unit.
Oh.
So I think that's what needs to happen first, because if that hasn't happened, the answer from the court is going to be no, because it has to be someone who's approved. So I understand that parole is saying that you're paroled to that location, but you're going to have to let parole know that you're on probation for this.
If there is an issue, Judge, like I brought it up with Mr. Cavani, it's like he wasn't granted more than 8 years on any of his 21 counts. And that was in 2017. So he shouldn't be even on parole, to be quite frank. Is 8 plus, my math is bad, but 8 plus 17 is 25. And so this year he should have been removed, but it's showing when I pulled this NCIC this morning that he's paroled until 27, which would have been 10 years, which without any other account.
and we discussed that, Judge, and I did see it on the judgment, and I was talking to Mr. Villarreal about it. But it did seem a little bit strange.
And I guess that's my concern, is that if parole does correct it, we shouldn't be really taking guidance from parole.
All right, let's do this.
That's stack 5, so that's why it's 10 years.
Okay.
I'm sorry, what?
My client was telling me that he has stacked 5-year sentences, Judge. That's why it's.
Oh, maybe he'll big stack.
I looked at all the judgments and kind of they're a wreck, and I don't see any. I didn't see any, and I could be wrong, of any that were to run consecutive.
All right, let's do this, because there's a lot of confusion over this. One, I'm not the judge who heard this. That would be that guy right there.
Yes, ma'am.
And I don't know if there have been any conditions set for you for probation. And according to the state, I don't even know if you should be on parole. And if you should not be on parole, then somebody needs to correct that.
So the judge ran the 8s and the 5 concurrent with the stacked 5. That's what happened. That's why I have a 10 maximum year of TDCJ. So I have 1 year left to serve on parole.
Well, what I can tell you this, if the judgment doesn't say that,
then doesn't matter.
Not precisely.
Yes.
Precisely.
So
Lots of smiles. We've turned off the camera. Judge comes back. Audio's off still.
yeah, what he said. So we need to figure out what's going on here. But what I can tell you, if I rule on this right now, it's going to be denied because there isn't even a chaperone that's approved. I don't know what's happening with your other cases, but what I can tell you is what's in the judgment is what counts. It's not,
It's not what parole says.
just people thinking this is the way. Sometimes people make
Hello, miss.
mistakes.
How you
I
doing?
understand what you're saying. But I have to look at the judgment. Your attorney needs to look at the judgment, because if you should not be on parole, then it's probably best that you not be on parole. So we can recall this back for late January, or when would you like to recall it?
Well,
or we can call it later.
Judge, my concern for my client is, where he'll reside until January.
Not there. I can tell you
I
that.
understand that it's obviously.
Okay. All right. We're going here. What are you guys seeing? This. Okay. It's time for lunch. We need to take a break. We have not been very successful in our SovSit hunt today. We're not done. We're still holding out hope for this afternoon. Remember, open season on SovSits as far as filming them. So we're going to continue that. I'll be right out to grab it. My daughter's maybe lunch. That's why we're gonna wrap up. I'd like a warm meal with my family. We'll do that. Red Pen says it's lunchtime, LOL, even though I could go a few more hours. And even when we go to lunch, you have to go to the post office and come back and open the package live. I do have to run to the post office. We'll do that. All right. Red Pen's like, thanks, Little Miss Alright. Just deal jurisdiction. Yeah. Tonight when you go home, please hug the people you love. Smile at someone, make their day just a little bit better. And please stay safe. Do go live again this afternoon. Give me an hour. Can we do that? We'll schedule. Okay, we've got Tuesday afternoon set up. We're just making the link right now. It's going to be 1:45. It's the pop back time. Up. Greeners is first in chat. And the portal is being created right now. There we go. And that's how we know we're coming back. We have a portal. Can I call after the stream ends for a quick super techie cable? Yeah. Give me a call. As soon as it goes dead, I'll be sitting right here. Actually, I'll be eating rice-a-roni for lunch is what I'll be doing, but I'll talk to you for sure. Sounds good. All right, you guys have yourself a great lunch. We'll be back in a little bit. We are going to find us some soft sits. I'm convinced. There's some out there that just need to be found. Oh no, I need a picture. Wait for it.